International Conference on Private International Law in the era of new emerging technologies, issues, challenges, and the way forward, jointly organized by VIT-AP School of Law in collaboration with Indian Society of International Law. We are deeply privileged to host this august gathering at the time when the world is witnessing an unprecedented technological transformation. Artificial intelligence, blockchain, cryptocurrency, big data, and the metaverse are rapidly shaping commerce, communication, governance, and dispute resolution across the borders. These developments bring immense opportunities, but they also raise complex legal questions relating to jurisdiction, conflict of laws, privacy, enforcement of judgments, digital sovereignty, and accountability. This conference is therefore both timely and necessary. It provides a vital platform for the scholars, judges, practitioners, policymakers, researchers, and the students from different parts of the world to come together, exchange ideas, and explore practical solutions for the future of private international law in the digital age. I warmly welcome each and every one of you and wish you a productive, insightful, and memorable conference. Thank you, and once again, welcome. May I now request the guest of honor, the chief guest, Vice Chancellor Sir, Registrar Sir, Dean Sir, to please come on the dais. I request our esteemed dignitaries to kindly come forward for the ceremonial lighting of lamp. May I request Dr. Gandhi sir to please come on the dais. Thank you very much. I now have the honor of inviting Professor Dr. Banerjee Chakka, Dean of VIT-AP School of Law, to deliver the welcome address.
So very good morning to all of you. Students, can I hear your voices? Thank you very much. And of course, all of you are awake and must be gearing up for this two-day international conference. And I take this opportunity once again, offer my warm welcome to the warm Vijayawada and Amravati city, a city which is growing up. And esteemed Vice Chancellor, sir, Honorable Chancellor Dr. Vishwanathan, sir, respected Vice Presidents, respected Vice Chancellor and Registrar, dear Chief Guest, Dr. Luther Rangareji, Additional Secretary, Legal and Treaties Division, Minister of External Affairs, and who is graciously agreed to come to inaugurate this particular session and the two-day event. Very prestigious opportunity for private international law aspirants. And I welcome all of you, sir, on behalf of VIT-AP University and VIT-AP School of Law. And I also welcome in absentia our Vice President, Indian Society of International Law, who is joining in online from Dharmasthala National Law University, Dr. Manoj Kumar, President of ICPIL. And I also extend my warm welcome to the esteemed Vice Presidents of ICPIL and esteemed Executive Councils of members of Indian Society of International Law and the Chief Editor of Indian Journal of International Law and Executive Vice President of Indian Society of International Law, and a guest of honor this today's inaugural program, Dr. V.G. Hegde, sir. Thank you, sir, for joining with us and to deliberate upon the important topics of private international law in the new and emerging technologies. And it is also gives me immense pleasure to all the keynote speakers, Dr. G.G. Hegde, sir, from NLS Bangalore, Dr. Sunil Kumar Agarwal, Advocate, Supreme Court of India, and Dr. Kondaya Jonnalagedda, a Professor of Law at Maharashtra National Law University, Shambhaji Nagar, and Professor Y.S.R. Murthy, Pro Vice Chancellor of Law at SRM University, Chennai, Dr. Soumya K.C., Director, Legal and Treaties Division, Ministry of External Affairs, Government of India, and Dr. Stelina Jolie. She is a Senior Associate Professor, South Asia University, Faculty of Law. I warmly welcome all of you for this academic session to deliberate upon this topic. And I also welcome our esteemed deans, directors, Director of Center of Excellence, Head of the Department, and my dear faculty colleagues, and my dear students and scholars of VIT-AP School of Law. And as you all know that it is a wonderful occasion to deliberate upon the aspects of the private international law. And most of the law students across the country, they are not much aware of the practicing and lively area of private international law. If you are having some zeal to explore the opportunities of family law, succession, service matters, if you club with private international law, that is going to be a very good practice area for the days to come, and it was and it will be. This is one of the interesting areas for all the students and scholars of law. And second, today we are taking this opportunity, the days where we have the intruding effects of the technology, that is a new and emerging technology, such as blockchain technology, large language models, and based on artificial intelligence and currency, where the central banks, particularly reserve banks, are speculating to protect the digital assets on the virtual spaces. And if you look into that, it is in a challenging aspect. Why it is a challenging? Today, we know that earlier we used to use the physical currencies, notes and coins, but all of you have shifted very quickly after the COVID-19 to the digital transactions. I don't think any of you today carrying bunch of notes or maybe handful of coins in your pockets. All of you are, whenever you purchase, even the roadside vendor, you are just taking your smartphone and making the payments. It is that kind of digital revolution we are living. But today it is not stopping with that, and it is also reaching across the borders. People are expecting to make their currencies in the digital form and creating the digital assets, and they are transacting and trading across the platforms and across the jurisdictions. And when this particular thing happens, obviously you require regulation and legal protections. What happens? Your digital assets have been scammed, and digital assets have been taken away and wrongly transacted, maybe taken away by the some kind of problems of the virus. How are we going to protect? And as we all know that these digital assets are not only based on a particular jurisdiction, but it is cross-border in nature. When you are creating your digital assets in the platforms, then if somebody is scamming from across the world and you do not know where the scamsters are sitting, or maybe because of cyber frauds which are happening, we have to have the recourse from the legal system. And when the recourse is not happening within your jurisdiction because of lack of harmonization of rules or unification of the rules, we will approach private international law for the enforcement and for having a jurisdiction. The states must strive to have a harmonized rules and unification of the rules with regard to the protection of the digital assets on the platforms. So in this background, we are going to deliberate upon these 2 days, the International Conference on Private International Law and New and Emerging Technologies, issues, challenges, and way forward. We are not simply discussing the problems. We are planning to promote the way forward so that our suggestions and solutions can be create an opportunity for tomorrow to have the regulatory mechanisms. So to deliberate upon, we have the 16 keynote speakers, and we have 160 papers have been received across the world. And the notable keynote speakers we have here with us, and also there are 3 people joining from across the world, and one Professor Veronica Ruiz, and she is the professor of private international law and a member of a permanent court of arbitration, and she will be speaking today at 2:30 Indian time from Edinburgh, and she is the one who is promoting the obligations of the state with regard to the protection of the digital assets, and she is also one of the listed arbitrators for the private international matters in the Permanent Court of Arbitration, which is situated at Hague, Netherlands. And we are also having participants from the across world, and we selected 140 papers, and out of 140 papers, we have received 90 full papers, and all those things are discussed at this platform. I'm sure all these papers are going to provide us an opportunity to create an ecosystem where we have regulatory and policy things. And our esteemed Minister of the State of Andhra Pradesh, Sri Kondapalli Srinivas Garu, and he, due to his urgent meetings and World Bank team visiting in Amravati and his hometown, that is Vijayanagaram, he is occupied and is excused for that. But he can at any time call us on, and he is asking that if any of the resolutions have been taken after this particular session, he would like to go through that, and he wanted to offer his solutions because he is the member of NRI Empowerment and Minister for the state of Andhra Pradesh. He is very keen on that. He is also promising that through MSMEs, NRI thinks he wants to VIT-AP University to collaborate with this ministry and provide some solutions in the disputes which are happening among the MSMEs. He wants to establish a nodal center and in our university. This is a great movement for the VIT-AP University and VIT-AP School of Law, and I thank our esteemed management, the Chancellor, Vice Presidents, and Honorable Vice Chancellor for their constant support and encouragement, and I welcome you all for this two-day gathering and also international conference. I am sure you definitely will enrich at the end of the 2 days and have the more and increased and enhanced knowledge of private international law, particularly in the digital realm. Thank you very much.
Thank you very much, sir, for your warm words of welcome and encouragement. We now proceed to the address of guest of honor. Dr. V.G. Hegde is the Executive President of Indian Society of International Law and a distinguished professor of international law at Jawaharlal Nehru University, JNU. An eminent scholar in the field of public international law, international economic law, trade law, he has made significant contributions to the legal research, teaching, and policy discourse in India and abroad. With extensive academic and professional experience, Dr. Hegde has been associated with several national and international institutions and has authored numerous scholarly publications. He is widely respected for his expertise in contemporary global legal issues and for his enduring contribution to the advancement of international legal studies. I warmly welcome Dr. Hegde, sir.
Good morning to everybody. And first of all, Honorable Vice Chancellor of the VIT-AP University, Dr. Banerjee, who is the Dean Faculty of Law, VIT-AP University, Dr. Luther Rangreji, Additional Secretary, Ministry of External Affairs, Dr. Gandhi, former Joint Secretary and currently the Vice President of the Indian Society of International Law, also an eminent professor, and all my dear colleagues, both from the Indian Society of International Law and also from the faculty here in the VIT-AP University, and most importantly, my dear students, and also colleagues from the faculty from the VIT-AP University. I think it's a great privilege for us in the Indian Society of International Law to collaborate and to organize this very important international conference on the issue of private international law, how private international law interacts with the emerging new technologies, basically. The term is new technology because today we are living in a world where technology is actually leapfrogging, actually. It's simply developing at a very, very faster pace. So it has been affecting the emergence of technology in the last at least 2 decades, has been affecting our lives in different ways. Already Professor Banerjee has put it so well in his introductory remarks. And also it affects our lives, particularly day-to-day lives, for example, in many ways. So it is important as lawyers, particularly for students, to understand and to execute, perhaps practice at a later point of time, the principles that arise out of this particular, particularly international law, private international law, even in the domestic law. Now, in this case, in this conference, we are looking at the most important aspects of private international law. I will say one 1 or 2 minutes about private international law, and then maybe later I'll speak at some point of time. The most important part of private international law is part of public international law, but at the same time, private international law is uniquely placed because it actually it's at the intersection of private law and international law actually. At the cross-border, all cross-border transactions, all cross-border issues actually fall within the realm of private international law. In this case, basically state may not be entirely an actor. State could be an actor, but at the same time, there are a number of private parties who actually will be the actors in the transactional links, and then how it affects sometimes largely affects the large population of trade, commerce, and also our own personal lives actually. Private international law is one aspect of private international law is obviously relating to the aspect of the contract, etc., but at the same time the trade, etc., but at the same time it also deals with issues relating to personal laws, including divorce, then adoption, and many important things. So I think it is really apt and proper that this particular international conference in collaboration with the Indian Society of International is being organized with our one of the major aspects or major contributions or one of the major requirements of Indian Society of International Law is to disseminate and to help all over the country, maybe in the entire developing world, to disseminate international law and private international law, including all branches of international law. So in that sense, we organize various programs in collaboration with various well-known universities like VIT and VIT-AP and other universities. At the same time, we also welcome students and faculty to Delhi, where our office is located just opposite Supreme Court, where we have an extensive library, extensive expertise, and we also teach some courses in international law and private international law, where our colleagues and faculty actually work on various aspects of international law. So I urge students and faculty, I'm sure many of you know, particularly our faculty colleagues know about it, to visit Delhi whenever it is possible. I know most of the things are online available, but still it is always a pleasure to be there in Delhi and to welcome all of you on behalf of my colleagues to Delhi whenever you are in Delhi to the Indian Society of International Law. So with this, I once again thank the Dean and other colleagues, including Honorable Vice Chancellor, Registrar, everybody, for arranging this wonderful conference in this city of Amaravati and the VIT-AP Law School. It's a great privilege for all of us to be here. Once again, I thank my colleagues who have come from Delhi and other parts of the country to participate in this program. I'm sure we look forward to have a great deliberation and outcome of this particular, great outcome of this particular conference. Once again, thanking you, all of you, and also I have few things to say, which I think I will say at a later point of time. Thank you very much.
Thank you very much, sir. We welcomed you and you welcomed us in return. Thank you very much. We now proceed with the address of Dr. Gandhi, sir. May I request Dr. Gandhi, sir?
Respected Vice Chancellor, Dean of the Law School, Dr. Rudra Rangreji, the Additional Secretary, Legal and Treaties Division, my former colleagues in the L&D Division, my colleagues now in ISIL, and all the colleagues, professional colleagues, my dear students. It is interesting to have the conference organized on this title, Private International Law in the Era of New Emerging Technologies issues, challenges, and the way forward. We had a conference organized in Indian Society of International Law on Private International Law in 2006. I was browsing through the conference papers before coming here. I found that only matrimonial disputes, child adoption, inter-country adoption, things like mostly the family law issues. Not much about the technology aspect, how that are being used. Unfortunately, in 2006 conference also, I did not see any papers presented on the private international law of torts, private international law of contracts. So the entire private international law, the world looked through the Indian legal prism for the past 20 years or so is only a private international law on matrimonial causes, child adoption, then displacement of child by certain laws and how to recover them. That's all. I think this is a new beginning that VIT-AP school started on that, to link technology with private international law. This is very essential. Also, it is a complex matter because when you apply lex fori, what happens is finally how that the local law reacts to that, whether they have law or not. And if it is so, when you have the transaction between two different systems of law, how you will discover evidence and put it there and go on the legal process. These are all complicated issues. Anyway, this is a right time. We have to look on that and we have discussion on that and it would be fruitful. Thank you.
Thank you very much, sir. We now proceed to the presidential address. I now respectfully invite Dr. P. Arulmozhi Varman, Vice Chancellor of VIT-AP University, to deliver presidential address.
Very good morning. Good morning. Distinguished guests, eminent scholars, respected delegates, members of the legal fraternity, and my dear student friends. Once again, good morning to all of you. It's both privilege and the profound responsibility to address this august gathering at the time of convergence of the two-day international conference on the private international law in the era of the new emerging technologies, issues, challenges, and the way forward, organized by the VIT-AP School of Law in collaboration with the Indian Society of the International Law at VIT-AP Amravati. First of all, many congratulations for the Dean and the entire team of the VSL for the great effort in organizing this thing. It's a very important time. We are in the convergence of the artificial intelligence and the private international law is redefining the foundations for the entire legal thought and the practices. We are very much thankful to all our the guests, especially Dr. V.G. Hegde. Yes, extensively addressed and made the clarity in terms of the international level of the private law at this junction. And I thank for the Dean VSL for given the complete, the elaborate and the details of the importance of the international level of the private law. And also I thank for the Mr. Gandhi for addressing this together with the issues with the general law as well as the boundary between the international law for the in this digital era. Thank you very much, sir, for all your the kind presence and the motivating and the inspiring level of the addresses. Today we have the Dr. Luther Lectronji, the Additional Secretary, Legal and the Trades Division, the Ministry of External Affairs, Government of India. Thank you, sir, for your the kind presence today and then enlightening us with your the kind presence and for this the two-day international level of the conference at VIT Amaravati. Honorable Chancellor and our the respected the Minister, both they supposed to be here and due to the emergency commitment in both the ends from the Honorable Chancellor as well as the Sri Kondapalli Srinivas Minister because of the World Bank team is visiting and then he is responsible for taking care of this, the MSME and the NRI empowerment activities. So he is combined with them for this, the today's thing. So we respectfully thank their the kind messages for this, the two-day international level of the conference, come out with the more interactions and also for the resolution to support for the government to take it in the further process. Let me begin with this, the powerful reflection from all these, the leaders. Law must evolve not only with the society, but ahead of it. Anticipating the future and it seeks to regulate. That's where the entire law regulations is coming into the picture. Today we stand at precisely such a moment. Private international law, traditionally concerned with the jurisdictions, choice of law and the enforcement of the foreign judgments, now faces the unprecedented challenges in the era of the digital transactions and the interactions transcend borders effortlessly. In the AI era, especially for the artificial intelligence system operates across the jurisdiction, often simultaneously raising the fundamental question. Which law applies? That's where the international private law is going to give the clarity here. Who bears the liability because of this, the digital era? How do we enforce justice in the borderless digital ecosystem? Because we are in the digital transaction, okay? As a research indicates, AI technologies inherently cause and create the cross-border externalities, regulatory arbitrage and interoperability challenges. That's where when I discussed with the additional secretary, yes, mentioned that we are dealing with such a complex level of the challenges. These are not abstract concerns, they are the real and also the immediate and deeply consequential. Recent developments in the legal practice, it illustrates this, the transformations. That's where every law school, they are taking the greater effort to promote this, the international private law. Courts are increasingly scrutinize the use of the AI tools, emphasizing the accountability, the human oversight in the legal process. The message is clear, AI can assist, but cannot replace the legal responsibility. At the same time, the integration of AI into the international arbitration and the dispute resolution highlights both opportunity as well as the risk. So we have to consciously work with the AI enhance to efficiency and reduce the cost. It also exposed the regulatory vacuum in the disclosure standards. We don't have the proper standards to draw the line how far the AI tool can assist with the ethical use and the accountable level of the frameworks. I appeal and request the forum to discuss the key challenges before us, the jurisdictional complexity, especially with the AI system, which blur the international businesses, boundaries, and making the traditional jurisdictional principles increasingly inadequate. Accountability and the liability, determining the responsibility among the developers, users, platforms remain legally ambiguous. We don't have the proper AI for the legal boundaries. Regulatory fragmentation, we appeal the divergent national laws create the enforcement challenges and risk for the regulatory arbitrage. The ethical and the human rights concerns also is the very important thing. We need to balance the innovation with the privacy, fairness, and the transparency is crucial. So what the opportunities are ahead at this juncture by focusing ourselves into the AI era in terms of the international private law. Yet this disruption is not merely a challenge because we are also to cross over the every transformations. It is an opportunity. AI intelligence holds the potential to enhance legal predictability and the consistency, improve the access to the justice globally, assist in harmonizing the complex legal system, enable the data-driven dispute resolution mechanism. This is where the AI is getting into the picture. AI could even help resolving long-standing complexities in the private international law by modeling and navigating the multiple legal systems simultaneously. What is the way forward? From here, we have to move in terms of this, the international private law to strengthen our the international cooperations. That's very important. That's where the government bodies are getting into the picture. The representation from the legal and the trades division of the Ministry of External Affairs play a major role to strengthen our the international cooperation, develop harmonized legal frameworks, which blend the soft law as well as the binding the regulations will be the essentials. Ensure ethical AI governance, that is the most important thing for the transparency, accountability, and the human oversight must be remain central. Promote the interdisciplinary level of the collaboration. So I appeal to the Dean VSL and the faculty colleagues, research scholars, and the students' friends to collaborate with all the disciplines because now no longer we are to operate separately. So we need to work and promote interdisciplinary collaboration. So lawyers, technologists, policymakers, and the academics must work together. As a role of universities, we are play a major role to foster the research in all the intersection of the law and the technology. That's where all our the deans from the other schools are the representing here to equip the students with the multidisciplinary competencies, serve the thought leaders in shaping the global legal disclosures and the discourse. At VIT-AP University Amaravati, we are committed and nurturing such innovation-driven the scholarship, contributing meaningful to the global policy dialogue. I appeal the conference, deliberations to reimagine the architecture of the private international law. With this, the strong deliberations and exchange of the ideas, build the consensus and shape the future with the law remains relevant and the global coherent. Because ultimately technology may be global, but justice must be the universal. Thank you and wish the conference team with the great success and the purpose of this the society. I heard that the more than 140 papers has been submitted, and out of that today 90 plus papers going to deliberate, and then they are coming out with the fruitful and the wonderful level of the resolution to help not only for India and also for the entire universe. So justice is the most important thing to remain harmony and also to take care of this, the empathy of the public. Jai Hind. Thank you.
Thank you very much, sir, for your visionary leadership and inspiring words. Now we proceed to the inaugural address. I deem it a great honor to invite erudite Dr. Luther Rangreji, sir, Additional Secretary, Legal and Treaties Division, Ministry of External Affairs and Government of India. I'll take a brief minute to introduce Dr. Luther Angrezi, sir. With an illustrious career spanning over 3 decades in international law and diplomacy, he is one of India's foremost practitioners of public international law. His areas of specialization encompasses law of sea, international organizations, international environmental law, and other areas of international law. Over the course of his career, he has dealt with a wide range of complex issues, including extradition, International Criminal Court, the work of International Law Commission, United Nations Affairs, collective security, narcotics, international terrorism, climate change, biodiversity, biosafety, just to name a few. Prior to his current role, Dr. Angrezi served as a Joint Secretary in Ministry of External Affairs. He was also deputed to the Faculty of Legal Studies, South Asian University, New Delhi, as Associate Professor, where he pursued his passion for teaching and research. Earlier in his career, he served as a senior legal officer in ALCO, New Delhi, an international governmental organization. Dr. Angrezi is a visiting faculty at several premier institutions, including ISIL, ILI, WWF, etc. It's a great honor to have you here, sir. We now welcome you for the address.
Good morning, Professor Arul Mozi Varman, Vice Chancellor of VIT-AP University, Amravati, Professor V.G. Hegde, the Executive President of the Indian Society of International Law, Professor Manoj Kumar Sinha, who is not here, the President of Indian Society of International Law, Dr. Mudiganti, the Registrar of VIT-AP University, Dr. Gandhi, the Vice President of Indian Society, my former colleague in the ministry, Dr. Banerjee, my friend and the Dean of VIT-AP University, Professor Stelina Jolly, my colleague, Dr. Soumya, Professor Murthy, Professor Kondaya, Dr. Sunil Agarwal, my friend Govindraj Hegde, the faculty here in VIT-AP University, the faculty in the VIT-AP School of Law, and above all, student friends. I took this time to introduce all of you because I have now been given an extended time of 20 minutes, and which I will try to fulfill. The advantage in serving in the government is you come prepared for many exigencies, a shorter statement and a longer statement. In a lighter vein, Dr. Banerjee, so when you told me that you have more time to speak, I thought, let me make use of it. It's an honor to be here, to be invited to inaugurate this two-day very important international conference on international law in the era of new emerging technologies, issues, challenges, and the way forward. And I think, VIT-AP University and the School of Law has, along with the Indian Society of International Law, has done a great job in organizing this very important conference. Traditionally, international law, especially private international law, deals with factors such as domicile, residence, place of contracting, what we call as lex loci delicti. All of these generally, they deal with legal relationships having a very clear, discernible territorial link. These questions, as you see, are related to matters that are tangible, in terms of people, in terms of property, in terms of contracts, having very clear, fair, clear geographical anchorage. However, in present times, as the topic of this conference deals, technology has given a fundamental shift to this practice, wherein issues relating to private international law are no longer just a procedural tool, but in many ways have become the point of engagement in revolving and resolving many uncertainties. Transactions today that are designed in one country are executed through servers in others, and they may produce legal consequences across several jurisdictions simultaneously. In such situations, you have a digital environment where the connecting factors themselves have become very fluid. The place of contracting, say, in an issue is of a smart contract, the locus of harm in an online tort, or even the situs or the situs, as they call, of a digital asset may not be very easily to pin down. This has resulted in various doctrines such as forum non-convenience and party autonomy being stretched in ways no one had ever anticipated a few years back. Private international law, as is well known, deals with issues that are often seen as a discipline of a connector. It doesn't decide a dispute, but answers three foundational questions. One, what is the code of jurisdiction? Two, which is the law applicable? And three, whether a foreign judgment deserves recognition and enforcement. Cross-border disputes are now evolving, and courts no longer are working alone. Much of the structure of rules of private international law are being shaped by three bodies: the UN Commission on International Trade Law, called as UNCITRAL, the Institute for Unification of Private Law, called as UNIDROIT, and the Hague Conference on Private International Law, which is also called in its abbreviated form as SCCH. But their collaboration is not in the form of a single treaty, as anybody familiar with the field of private international law would do. They do not attempt to unify a single code, but they work in unison and cooperation a number of areas which this conference would be dealing with. For example, the UNCITRAL focuses on making cross-border transactions legally more workable. It works on issues such as electronic commerce, digital trade, electronic transferable records, and that ensures a transaction taking place online is not dismissed simply because it lacks paper form. The UNIDROIT deals with subjects that step into the conceptual gaps, and it deals with subjects such as the principles of digital assets and private law, trying to answer what kind of rights exist in digital assets, something courts are already struggling with in disputes involving cryptocurrencies and tokenized value. The Hague Conference on Private International Law addresses the moment where disagreement begins. It focuses on issues: how legal systems interact, which courts should hear a dispute, which law would apply, and whether a decision would be recognized elsewhere. The SCCH deals with these matters through the Judgment Convention, the Service Convention, the Evidence Convention, and now it is taking various other digitalization initiatives that show that even procedural cooperation is being rethought in the light of evolving technologies. There are some examples which I can give, such as digital economy, which aims to modernize cross-border civil procedures and evidence rules to reflect electronic communications, e-commerce, and online dispute resolution. The relevance of this study of digital economy lies in the fact that it tries to reduce friction in cross-border litigation and evidence gathering for technical disputes. Issues regarding digital tokens and digital assets projects, which tries to again address issues regarding cross-border tokenized assets, jurisdictional questions, recognition of transfers, registry corrections, remedies of wrongful transfers. The relevance of this study lies that it directly tackles how courts should treat token ownership and transfer across borders. You have a project called as a CBDC, the Central Bank Digital Currency Project, that examines legal and private law implications of CBDCs, including cross-border payments, interoperability, and recognition of claims denominated in digital central bank monies. The relevance lies in how these digital currencies would affect private law obligations, cross-border payment, finality issues, and insolvency priorities. You also have jurisdiction and judgment projects that are being undertaken by the SCCH that try to modernize connecting factors and recognition for rules to account for digital transactions, remote contracting, and decentralized systems. The relevance of this project lies in providing procedural framework for enforcing remedies in technical projects. The sessions, I think, are very relevant, Professor Banerjee, which you've called out. One deals with jurisdiction and conflict of laws in a digital age. I think we are seeing increasingly such disputes where facts refuse to sit in one country. As earlier speakers have said, a fraud might be occurring through a crypto wallet registered in one jurisdiction, routed through servers in another, and affecting victims sitting in India. You also have, these issues which need to address, problems of jurisdiction, not only where it has happened, but where the effects of these frauds are felt. And this is still an evolving principle. As I said earlier, UNIDROIT deals with principles of digital assets and private law. Session 2 deals with recognition and enforcement of foreign judgments in technology-driven dispute. As opposed to traditional rules of private international law, enforcement, which was already complex, but with digital assets now it has become almost abstract. In commercial disputes, enforcing outcomes arising from smart contracts or digital transactions would raise issues regarding how such agreements are characterized and whether they meet legal standards across jurisdictions. Arbitration and online dispute resolution are being increasingly used, but their outcomes will depend on recognition by national courts. Session 3 is an important aspect on data protection, digital sovereignty, privacy in a globalized world, dealing with India's Digital Personal Data Protection Act. There's a long thing I have written. I don't want to take time. You have a UN Convention on Cybercrime that indicates growing international efforts to address cross-border digital issues, including data access and cooperation. From an private international law perspective, the challenge remains significant. The last session is dealing with emerging technologies and the future of private international law. I think, some of the most difficult issues and questions of rules of private international law are now coming from spaces where the law has no settled vocabulary. Issues such as, ownership are itself being coded and they only exist in a blockchain where the location, even for legal purposes, is not, known. Take, for example, AI-generated contracts or smart contracts. If an algorithm autonomously executes a transaction, attributing intent or liability would become far more complex. In the light of all these statements, I believe you have a conference that is most apt and, it's very contemporary. And India being a member of the SCCH, the UNCITRAL, the UNIDROIT, actively participates in the work of these international organizations. I think the conference is important not only just in identifying the problems which rules of private international law have today or pose today, but it would also be important to align perspectives which can include academic, judicial, and policy-driven. And I take this opportunity once again to thank VIT-AP University for calling me for this inaugural session and wish the conference a great success. Thank you.
Great, sir.
Thank you very much, sir, for your kind words. We now proceed to the felicitation of our guests. I now take this moment to felicitate the esteemed dignitaries as a token of our gratitude and respect. Come. Thank you very much, sir. We now proceed to the vote of thanks. I now invite Dr. Banerjee C. Shaji, conference convener, to propose vote of thanks.
A very good morning to one and all present here. Respected Chief Guest, Dr. Luther Langreji, sir. Honorable Guest of Honor, Professor V.G. Hegde, sir. Honorable Vice Chancellor, Dr. P. Arulmozhi Varman, sir. Respected Registrar, Dr. Jagajeesh Chandra Mudugandi, sir. Dr. Manimuthu Gandhi, sir. Our esteemed Dean, Dr. Banerjee Chakka, sir. Distinguished dignitaries on and off the dais, esteemed delegates, faculty members, researchers, and my dear students. It is my proud privilege to propose the vote of thanks on this memorable occasion of the inaugural ceremony of our International Conference on Private International Law at VIT-AP University in collaboration with Indian Society for International Law, New Delhi. With profound respect, we convey our sincere gratitude to our Honorable Chancellor, Dr. G. Vishwanathan, sir, in absentia, whose inspiring vision and unwavering commitment to quality education and continue to guide and strengthen all our endeavors. Our heartfelt appreciation also goes to our respected Vice Presidents, Dr. Shankar Vishwanathan, Dr. Shekhar Vishwanathan, and Dr. G.V. Selvam, sir, for their dynamic leadership, constant encouragement, and continuous support in taking VIT, especially VIT-AP University, Amaravati, to greater heights of excellence. I express our deepest gratitude to our esteemed Chief Guest, Dr. Luther Rangareji, Additional Secretary, Legal and Treaties Division, Ministry of External Affairs, Government of India, for graciously inaugurating this conference and for sharing his valuable thoughts and inspiring insights with us. Your presence has truly elevated this occasion, and your words will remain a source of motivation for all of us. Thank you so much, sir, for joining us today. I extend my heartfelt thanks to Honorable Guest of Honor, Professor Dr. V.G. Hegde, sir, Executive President, Indian Society of International Law, whose distinguished presence and scholarly reflections have added immense value to this gathering. We are truly honored by your encouragement and support. Thank you so much, sir, for joining us today. I offer my sincere gratitude to our Honorable Vice Chancellor, Dr. P. Arulmozhivarman, sir, for delivering the presidential address and for his visionary leadership, constant motivation, and unwavering support in promoting academic excellence and global engagement at our university. Thank you so much, sir, for gracing this occasion. My special thanks to Professor Dr. Manimuthu Gandhi, sir, for addressing the gathering and for your continued guidance and support in successful organization of this conference. Thank you so much, sir. I would also like to warmly appreciate our esteemed Dean, Dr. Banerjee Chakka, sir, for gracious welcome address and setting a wonderful tone for this prestigious event. Your dedication and tireless efforts have been instrumental in bringing this conference to life. Thank you so much, sir. I also wish to sincerely acknowledge and thank the organizers, faculty members, staff members, student volunteers, participants, and delegates whose dedication, coordination, and enthusiastic involvement have made this inaugural ceremony possible. To all our distinguished guests and participants, thank you for gracing this occasion with your esteemed presence and for strengthening the spirit of academic dialogue, collaboration, and shared learning. With gratitude in our hearts and great enthusiasm for the enriching sessions ahead, I humbly conclude my vote of thanks. Thank you, one and all.
Thank you very much, sir. May I now request all the faculty members of Law Department to please come to the dais for a group photo. I request all the ISIL members first, as a token of respect, for a group photo. Yes. Thank you very much. I now request all the faculty members to please come on the dais for a group photo. Faculty members of Law Department.
Come up onto the dais. Good morning, sir. I now take the privilege to introduce you all our session moderator. Dr. Anantu S. Harigaru is Assistant Professor at VIT-AP School of Law. Sir is now currently the Assistant Dean of VSL. Graduating from Mahatma Gandhi University, Kerala, Sir completed his LLM and PhD from IIT Kharagpur, specializing in intellectual property laws. I now request Sir to please take over the session.
Thank you, Likita. Good morning to all. It is my now great pleasure to welcome all of you to the first technical session of the international conference on the theme Private International Law in the Era of New and Emerging Technology, Issues, Challenges, and the Way Forward, organized by VIT-AP School of Law in collaboration with the Indian Society of International Law. So we are truly honored to have with us a very eminent scholars and experts in the panel who will be deliberating on the various facets of private international law. Before we commence, may I briefly outline the structure of the session. This session is scheduled for a total duration of 90 minutes. And in view of the depth of the expertise we are fortunate to have, and in order to ensure that each speaker has the opportunity to contribute meaningfully, we have structured the time allocation. Each keynote speaker is requested to take approximately 15 to 20 minutes for their address, and paper presenters are requested to confine their presentations to 8 to 10 minutes, and this will enable us to set aside adequate time for an engaging Q&A session towards the end. So it's a great honor for us to have three of the eminent speakers for our keynote addresses for this particular first technical session. We have Professor Manoj Kumar Sinha sir. Sir will be joining online. So first we'll be starting with Manoj sir's session. Manoj sir, am I audible to you, sir?
Yes, you are right.
Yeah, thank you so much, sir. So first of all, I will introduce Professor Manoj sir to all our students and university faculties and staff. We all know about Professor Manoj sir. He is a distinguished scholar and academic administrator, currently serving as a Vice Chancellor of Dharmashastra National Law University, Jabalpur, Madhya Pradesh. In addition to this role, he also currently holds the position of the President of the Executive Council of the Indian Society of International Law. He previously served as the Director of the Indian Law Institute, New Delhi, where he made substantial contributions to legal research and institutional advancement. He earned his doctorate in international law from Jawaharlal Nehru University, New Delhi, LLM from University of Nottingham.
I think let me continue so we can cut short the introduction. So
Sure, sir.
thank
Sure,
you
sir.
very much
Sure,
for-
sir. So we welcome you and we thank you for this opportunity of collaborating with Indian Society of International Law and for your valuable time. And we welcome you, sir, on behalf of VIT-AP University. Thank you, sir.
Thank you very much, my young colleague from VIT School of Law, respected Professor V.G. Hegde sir, Executive President, Indian Society of International Law, respected Sri Pradeep Rai ji, Vice President of the Indian Society of International Law and Senior Advocate, Supreme Court of India, dear good friend Professor Banerjee, Dean of the VIT-AP School of Law, and all colleagues from Indian Society of International Law. I believe Professor Jairaj, Professor Gandhi, Dr. Sunil, Saju Jacob, and others all are participating offline in this conference. I would also like to share, my time and also responsibility to Professor Hegde or my brother Professor Pradeep Rai sir, because I'm not very sound scholar of private international law. But I'll discuss with something which I have, but the topic is very important. Today we have selected. I would like to start with thanking Professor Banerjee for continuously taking lead when it comes to the private international from the part of the VIT-AP Law School of Law. And on the other hand, I would also like to take this opportunity to thank our colleagues from the Indian Society of International Law, the private international law team, the private international law committee headed by Pradeep ji, Dr. Sunil, Saju, Professor Jairaj, and all other members who are involved and continuously working for promotion and dissemination of private international law. This is the subject which some way not taken so seriously when it comes to the legal education in India, because this subject requires a serious scholar, and we don't have a serious scholar. We have a scholar who teaches the other fundamental papers of the law prescribed by the Bar Council of India, and that is the reason always each law schools, what I mean not national law school, I mean every law schools find it very difficult to find the resource person or human resource to teach continuously the private. And I hope that the initiative will be towards filling this gap. So in future, maybe more young students will join. Teaching private international law, broad theme of the conference in the age of artificial. When we talk about the private international law, I'm sure that all speakers will speak the 3-4 important aspects. That is the aspect related with the jurisdiction, the choice of law, the recognition and enforcement. That these are the important part of the private international law when we look into. And when we talk about the distinction between the private international law and public international law, state is like, main element. State is the main subject of the private or public international law. But when we talk about the private international law, it governs between the private individuals and also the businesses across the country. Private individuals, the disputes related to the private individual, and that is the reason jurisdiction becomes very important when we talk about the jurisdiction issue. Choice of law, where the marriage is performed, the child related with the child's their marriage, divorce in family matters, even trade matters. We see the choice of the jurisdiction becomes very fundamental. Application of law becomes very important in case of the case of the private international law. So it addresses the rules which governs the private international law. It takes care of the private individuals and businesses. So it has been for many years that private international, there is there are Hague conference, number of conventions are there, which India is also party of. Decide and they become the party of there. So the jurisdiction issue, the subject, I say that international contracts, family law, and the tort law, these are the broad subjects of the private international law. But when we come to a new area which we have been thinking about, the artificial intelligence, and when I talk about the artificial intelligence, which is a subject, it's a generating a debate both locally or internationally, for both areas, for the public international law as well as the private international law.
Deep Kumar Rai sir is a distinguished senior advocate and former vice president of the Supreme Court Bar Association. His legal expertise spans a broad spectrum, including civil, criminal, revenue, and constitutional matters. He is an active contributor to the institutional development within the legal fraternity and has been instrumental in establishing several subcommittees for the Supreme Court Bar Association. And he has also played a pivotal role in the registration of the Supreme Court Cooperative Housing Society and facilitated the allotment of land for the development in Noida. And his contribution further extend to organizing various public service initiatives such as driving license camps, passport camps, etc., and also the reopening of the railway reservation counter within the Supreme Court premise. So sir has also served as the chairman of the Indian Legal Aid Center and the Indian Legal Research Foundation. Through these platforms, he has promoted cultural and academic engagement by organizing competitions and debates for members of the legal fraternity and their families, fostering both talent and confidence over the years. So we welcome you, sir, to the technical session on the first technical session on private international law conference. Sir.
Respected Manoj Sinha ji, respected Professor Mr. Banerjee, Professor V.G. Hegde, Professor Gandhi, Anantu Sri Hari, Luther sir, Professor Y.S.R. Murthy sir, Sunil ji and Reddy sir, and young minds, all these young students who are here. And I hope that you all are liking whatever is happening here, because this is something unusual for the young minds, and generally most of them young students are not interested. But if you are interested and having the profession of law, it will be great benefit to you all. In the time of artificial intelligence and the virtual courts, we all are observing that how these courts, which were earlier in a formal environment, used to function, how they are functioning and how the decision-making process are being impacted. Many courts, they have developed their softwares. Even Supreme Court of India has developed, by which they get all the details of judgments, the facts of the case, and majority of the judgments which has been rendered and delivered, they all have those details, and thereby the decision-making process is easier. I don't say that there is no place for any default or fault. There are something where we all get confused at some point of time, because ChatGPT sometimes gives a judgment which is non-existent. At that point of time, we all sometimes feel that unless you see it, verify it properly, you should not mention any judgment. And many cases, Supreme Court has warned. But the major issue is that nowadays each and every citizen is being impacted by digital frauds. Sometimes you get a call and they get your OTP and PINs, however you open some unknowingly without being aware of some link, you open it and it directs you to somewhere where your money is siphoned, where you have been defrauded and cheated. The Supreme Court is recently considering the cases of digital arrest. In those digital arrests and these cyber frauds, if you go into detail, you will find that persons who are being defrauded and cheated and victimized, they all are educated people. They all are having very deep roots in the society, highly educated. And the persons who are cheating them, most of them are uneducated. And the centers of these cheats are new, somewhere in a village in Bharatpur, somewhere in Jharkhand, Jamtala. So ultimately, we all have to realize that why these things are happening and how these educated experts having great knowledge, those people are entrapped. First of all, we have to realize that countries has to develop the rights of citizens in regard to their digital property. Many of us who all have accounts on Twitter, Facebook or Instagram, maybe LinkedIn, you do not know that someone at some point of time, they hack your account. They may create some deep fake, they may post something. Few years back, Government of India banned, there was some calling system called crazy calls, by which you can call anyone from any number. You have to feed the number and you call, and the number reflected on the phone of receiver is the number which you have put in. So in those circumstances, and considering the current situation, we all have to be very careful. Digital rights has to be recognized, and governments, they have to, because sometimes frauds are sitting in Nigeria. Sometimes someone is looting and your multiple bank account transfers, you will find that it is landing into some country of Africa or USA or maybe Canada. So you do not know. And nothing is personal nowadays. I appeared in a matter where Aishwarya Rai's passport, because he went to when you go to foreign travel, they scan your passport. And that passport was everywhere on all the counters. So everybody is aware that what is her passport number, what is the age, everything, all the details, whatever a passport can carry, it is available to everyone. Despite having right to privacy, all these Aadhaar data is public. So, and even these websites, these social media accounts, they also need your all the details. They say that if you want to be verified, you share your Aadhaar, you share your government IDs, which is not proper. But in absence of any laws, in absence of any deliberation, in absence of any legislative exercise, or even notification or some kind of ruling, it is difficult for the agencies also to probe it. And whether we have the expertise to investigate those cases. Many states, barring Delhi and Bombay, even Bangalore is good, Chennai is good. Many states, they do not have even basic expertise. They have a cyber team, but that team is allocated for those officers who are being punished. Suppose your senior officer is not liking you, they will punish you and post you in the cyber crime. Most very lucrative post is traffic. Because traffic police, they can earn anywhere. There is no good police station or bad police station. So ultimately, the purpose of this reference is that first of all, you have to give training, proper training. Hyderabad recently introduced through an AI, a proper system by which the vehicle number itself will say that how many challans has been granted to this, what kind of violations are there, when you are jumping the red light, what is the nature of the driver, whether you are a serial offender or you are doing it once in a year. So considering those facts and considering the AI system, we all have to develop something by which the globally cooperation may be developed. Today something is happening, you do not know other than barring few countries like UAE and Singapore and all, whenever there is even arbitration award, section 44A, ultimately this 13 exception comes. And when the exception comes, what happens? We say that there can be parallel litigation. So this is in the regard to commercial matter. But in regard to these kind of fraudulent activities, where your entire data, your everything is going to be on the digital media and social media. Your house location is marked. Your daily travel program is also marked and mapped through maps, because everybody is nowadays a share location, and because you receive the location, your entire movement is tracked. Just anybody can go on the Google, unless you have switched on the privacy, they can see that where you visited, where you take the U-turn, where you made some mistake, where you stayed for 5 minutes, your all the data is available. So ultimately, if you deal with this situation, we will say this is like a frog in hot water. When frog goes in the hot water, initially, it doesn't realize that what is going to happen to him. but when the boiling points goes up, he dies. So similarly, when you enjoy digital media and digital platforms, you have to realize that what is your point, where you have to stop, where you have to be careful, what data you do not need to share, when you can be defrauded. So ultimately, all those things, if you do not remember and you do not deal with this, then it's really difficult for everyone. The blockchains, which was actually discovered by some pseudonym, that Nakatomo. So when it was discovered, he thought that we should have a cryptocurrency. That is the big challenge nowadays. Many persons are entrapped by the fake cryptocurrency. Day before yesterday, some company related to President Trump's children, they have forfeited the shares and this digital currency of some of the partners. So where is the protection? Suppose the person who has invested there is a citizen of India, how will he deal with it? Unless the US courts, they assume jurisdiction and they decide matters on many issues which is not related to them. When we respect the sovereignty and integrity of each and every country, and we respect the basics and the functioning of each and every country, being a democratic country, ultimately, when we are entrapped into such a situation, we do not know, our citizens do not know. So there should be a proper system which is to be educate, to propagate, to take the investigating officers into the laws, and legislative has to be trained. Unless legislative brings a law with a proper intent, because nowadays what happens, without discussion you pass a bill. When a bill is passed without discussion, you do not know what is the intent, where you have to stop. So interpretation may be multifold. It can have any interpretation. So first of all, you should recognize, identify the experts. Even I feel that whenever I have to deal with something, I always take support from young students like you all. You know better than us on many subjects. Whenever it is the question of digital media, you know better than us. You tell me what is the hashtag, how to deal with it. You do not open it. This is a fraud. Even my children, they understand better than us. So in such circumstances, we all have to engage some young minds. We have to see that how it's happening, how it is going to happen, what will be the future. You do not know. Down the line, after 3-4 years, you may find that there are some robo-servants serving the tea, not a man who is serving here. It may happen. It's not difficult. Nowadays, we have seen that even robo-warriors are there, and they are going for the war. Drone, you are sitting here and operating it. And even these missiles are recognized to the fighter jets, and they are firing, and they will chase where the plane is going, and they will hit it, the jet. So that is the issue. We all have this Budapest Convention on Cybercrime. We all accept it. But despite that, lot of things to be done. Hague Convention is there where agreements has to be honored. But ultimately, when you enter into an agreement, whenever you open your Gmail account, very simple thing, you all have to open it because you have to send an email to someone. You do not know, when you accept the condition and terms, how many of you read it? Many of us do not read it. Unless we have a responsibility to find out a fault in that agreement, even lawyers don't read it. So we all have to understand those things, and even Interpol, because whenever there is an offense, especially on cyber offenses, Interpol do not care for it. Because money laundering part, you register a case when a company is operating, when the target is easy. When a blind case is there, Interpol also do not take enough pain. Red corners notice are there, blue notice is there, purple notice is there. Purple notices work because you only need the information. In order to get the information, you are working on it. But even red corner notices, we see many persons who have defrauded and is staying in some country, they are almost in a protected way. We are not able to bring many of the offenders who are staying abroad despite the best efforts of Government of India. So ultimately, now in this era, when you do not know a person who is sending the email is sitting where, you do not know that who is operating which account. In those circumstances, we have to be very careful. We have to make the laws, our framers of the laws, the MPs, we have to make them educated if they are not, some of them, and some of them are extremely good, so they all can work. Responsibility of bureaucracy, legislation, and everyone to deliberate on it and have a proper legislation which is globally accepted. Because ultimately, when a law which you bring another country is not accepting, it will not be applicable. So considering those issues, we all have to work in a positive direction. I congratulate the professors and the other staffs of VIT-AP University who have organized this international conference, which has given opportunity all of us to interact with these young minds and meeting all our dear friends. Despite being in Delhi, some of them we cannot meet. So this is really a great opportunity. I congratulate you all for having such a wonderful opportunity to learn, and even for us, it's a learning experience. Thank you so much for inviting me and giving me this opportunity. Best regards.
Due to Sir's busy schedule, Sir is unable to continue for the rest of the session. So I request our Dean Sir, Assistant Dean, and our convener for the session to kindly felicitate Sir. Yes.
So now we will proceed to the next technical session. So we have Professor V.G. Hegde, distinguished scholar of international law, former professor and chairperson of the Center of International Legal Studies, School of International Studies, JNU. Sir had a long and influencing academic career, contributing significantly to teaching, research, policy engagement in international law and its interface with domestic legal system. He has also served as a faculty of legal studies, South Asian University, where he also held the position of associate dean. Earlier in his career, Professor Hegde also held senior positions at the African Asian Legal Consultative Committee and the Legal and Treaties Division of the Ministry of External Affairs, Government of India. Sir has also been part of several official Indian delegations engaged in negotiating and implementing international trade and bilateral investment agreements, and has represented India on the working groups of the United Nations Commission on International Trade Law. And his academic work spans public international law, international dispute settlement, intellectual property rights, international trade law, air and space law, international water courses, and the interface between international and domestic law. Sir is currently the Executive President of the Indian Society of International Law and also the Editor-in-Chief of the Indian Journal of International Law. So it's a great honor for us to have you with us today, and I welcome you to the technical session, sir.
So, Professor Manoj Sinha, President of the Indian Society of International Law, Dr. Anantu Hari, my colleague on the dais, and all the colleagues here, and then of Indian Society of International Law, also from the Faculty of Law from the VIT-AP Law School, dear students. So I am here to give so-called keynote address now, but I've already spoken in the morning, but I think I would rather say my speech would be more of a reflection and maybe something very substantive, possibly. Now, if you begin, since I'm talking to students and then colleagues, when we talk about private international law, as teachers or as practitioners, you always look at some of the basic textbooks like Cheshire, Diwan. In the Indian context, mostly Cheshire, I think, is one of the well-known. And then many of our colleagues over the years have worked on various aspects of private international law. But even now, on the core, I think still we depend more on the Western scholarship. Of course, we have India providing certain contributions to it. I'll come to it. But at the same time, as mentioned in the morning, private international law is essentially a part of public international law. There is no doubt about it. But in the context of private international law, as I mentioned again in the morning, we are looking at a cross-border kind of a situation. There are two parties. One of them is located in another jurisdiction. And then, or several of them could be in several other jurisdictions, and how to deal with it. As mentioned again by my dear colleagues in the morning, one important issue is about jurisdiction. See, for example, I'm sure there are parties who actually, are cross-border in the sense, for example, in case if you're taking up a big project, if you are doing some big building, I always give this example. Let us say somebody is building a very big building in Dubai. There are hundreds of contracts concluded between the parties. There is electrical contract, there is a foundation, relating to that contract, there is a mechanical contract, there is a contract for lift, there is a contract for, I'm sure even building a big building like this VIT is going to have some hundreds of contracts. All of them may not be in India actually. You have contracts with somebody who is outside Indian jurisdiction. And simply could happen that there could be a dispute, there could be a problem. There could be a matter of interpretation of the contract which you actually sign with the other parties. Then what do you do with it? Now, in case if there is a interpretative problems or disputes which might lead to dispute, then first thing is to decide which law will apply to that particular contract. Because when you have multiple parties located in different kinds of jurisdictions, the first point is applicable law. So from jurisdiction, we go to applicable law. Will Indian law apply because the situs of the project is in India, or situs of the project is in some other country? It depends. So there are very clear principles saying that for immovable property, it's very clear. For movable property, there is something else. So it is a bit complex world. Deciding this, because there are basic principles which have been worked out through case laws, etc., by the various courts around the world, which all constitute private international law. This is one part of the story. This is because where you have contracts, you have commercial transactions, you have so many things which are happening. Now, other side of the story is, as mentioned again, it also deals with personal laws. Personal laws, I'm sure all of you know. If I go abroad, for example, and stay somewhere, I carry with me, of course, all Indian laws, also my personal laws to other country. If I am going to stay in US or UK or any other country in Africa as well, I carry with me, with my family, the laws which actually, go with me. So, for example, if I am married in India, my children were born in India, then there is some problem which arises. Then obviously issues of adoption, issue of divorce, issues of personal law, basically nationality. All these also are also part of private international law. As mentioned by both my colleagues, Professor Manoj Sinha, most importantly by Dr. Luther Rangreji in the morning, my colleague in the morning, they referred to various international conventions. You have various international institutions dealing with, they're trying to codify these things actually. It's very complicated. It's not easy for a court. Our Supreme Court, I can tell you, our own Supreme Court across the road of the Indian Society of International Law finds it sometimes difficult to, how to arrive at a certain, because they have to exercise jurisdiction, they're not very clear. For example, there is what is called as, under the Hague Convention, which we are now party to some of the conventions after long debate, etc. Particularly personal laws relating to that. For example, if there is a husband and wife who get married, they go and settle down in US. They got married, let's say in Tirupati, and they went to settle down in US. And then there was a child born, and there was a dispute between them. And the wife takes away the child and comes back to India and stays in India. Husband files a case in US against the wife, saying that he kidnapped my child. Now, this is and US court issues a decree, and then the wife is in the Indian jurisdiction, husband is taken a decree in the US jurisdiction. Now the wife files a case in India against husband for whatever he has done. So how do you solve this problem? The private international has to find answers for all these things. This one personal law, another is, business, contract, etc. So basically it's a very important area actually, because it's happening all the time. Satya versus Teja, 1975 decision. Almost the same facts I mentioned to you now happened in the Satya versus Teja. Now after that, the kidnapping business, it's not called kidnapping, it's called abduction. The more more nuanced word is used in the Hague Convention. In case there is abduction, but it can't be a criminal case because it can't be, because wife also is a mother, so she also has the legal custody of the child. So how do you resolve all these things? Private international law provides answers to all these things. And it is going to happen on a day-to-day basis. It's happening. Supreme Court has dealt with several cases, from Tikku to Satya, starting from Satya versus Teja. I think at least 15 to 20 or 30 cases have been decided by the Indian Supreme Court. And I can proudly tell you that many of our colleagues in the Indian Society of International Law and other teachers who are dealing with this have advised the court, helped the court, assisted the court in many of these cases to understand how to exercise jurisdiction. To put it in simple terms, I was a desk officer in the Ministry of External Affairs many years ago, where my other colleagues are here also. When I was a colleague, one of the basic things which we were actually as, very young officers, then we used to get issues like how to serve a summons in another jurisdiction. It looks very easy to say, okay, serving summons in a court is a very important issue because court can exercise jurisdiction. But if somebody is in another jurisdiction, has gone abroad or various reasons, or siphoned off money and gone abroad and done something, it could be a criminal summons or it could be a civil one, how do you do it actually? Supreme Court did not have an idea about it actually. Because CPC doesn't clearly say, there is CPC section 44A provides list of reciprocal countries where you can do it through a diplomatic channel, etc. But it is a very difficult. Otherwise, you can through your embassy, or if there is a reciprocity, you can do it. There are a number of guidelines which have been provided there actually. that's one part of the story. So you need to, so where of course our colleagues, my colleagues here in the Ministry of External Affairs, elsewhere, they do it on a day-to-day basis. This is I did it for many years, learnt a lot of things, how to go about doing it, but these are very important issues. If you go to, even in Andhra or even in Punjab, there are a number of cases which have come up where husband and wife, or in two different jurisdictions, marriage, for example, somebody who comes to India marries, but he had already married somebody there, divorced, but there was not a proper divorce. Then what will happen to the wife here, actually? So we have dealt with these cases. Whether it's a valid marriage, first of all, you have to prove it's a valid marriage under the private international law. What is a valid marriage? So in case if the husband is a Hindu, wife is a Muslim, then you need to get information from various sources as to under which law, under Hindu law, Muslim law, personal laws, whether it's a valid marriage or not. Only upon that, sometimes I remember Canadian courts, for example, diaspora is very active there. The US now, Indians are in UAE, we have a high, almost 2-3 crores or 4 or 5 crores of people are abroad, and most of them get this kind of NRIs, get this kind of problems. Then you need to, the Ministry of External Affairs, Legal and Treaties Division particularly, has to find out whether this marriage is valid or not, and Canadian court is asking diplomatically, you are getting the, asking whether, because under international law, a particular definition or a particular sort of a, decision given by by us as an interpretation is final, actually. It's a fact before the court. In case Canadian court is dealing with it, if the Indian authorities provide the answer, that will be taken as a fact. So obviously Canadian court can't do anything about it. They will have to restate the fact. So it's a big responsibility for our legal colleagues to provide very correct advice. Otherwise it will affect the last man on the, it's very difficult for people, which includes the issues like maintenance, for example. Issues of maintenance we don't talk about because wives, particularly if you case Punjab, there is a whole lot of cases which are have come up because the husband goes away, wife is still in India. Now what about how to actually acquire maintenance? One way we used to do it is, remember, we had to impound the passports. But in case if the other party is foreign national, Indian origin, but foreign national, then how do you impound the passport? So how to actually get it done? So these are all bread and butter issues which PI, private international law, deals with. I just wanted to give you a sketch of how important it is. I'm sure many of you are going to deal with this if you are practicing wherever you go to practice in major cities. The second part is, now we are talking about technology, actually. We are talking about technology, emerging technology. I feel, although again I had an occasion to be part of the working group in the United Nations Commission on International Trade Law for some years, thanks to my boss, Dr. P.S. Rao, who was from this part of the world. He's one of the eminent international lawyers, and many other colleagues. And then where I was in the working group where the UNCITRAL, it's called United Nations Commission on International Trade Law, I advise all the students to visit their website. It started its work on e-contracting in 1996. I was a young officer at that time. I had joined the ministry, could able to attend some of these working groups, and we didn't know what Indian position was that time. India was actually looking at digitalization was coming up in 96, 97, 98. Many of you might not have even born at that point of time. Okay, so that time the e-contracting was the first one, and followed by e-commerce. Now e-contracting is basically, internet had just come, whether two parties can enter into a contract through internet, actually. That's the basic problem which started, actually. Now why it's important? Now all of us who study contract, basically, basic principle in contract is all contracts should be in writing. You can have oral contracts, of course, it has its limitations, but all of us have learned contract law. But in case if you have a dispute, you have to have, it should be in writing. But there is this problem, if you go into contract, okay, you write in contract, and then contract, if there is a dispute, it goes to dispute is done, then award is given, then there is how to enforce the award. Actually, I'm sure my colleague Gigi Hegde will say more on this. Enforcement of awards, New York 1958 New York Convention actually says one of the basic requirement is agreement should be in writing. Now, what is writing? Now, technology has changed the idea of writing actually. Is it writing means that what is there in the internet is writing? Can we take it as, in case if there is no writing? So I was part of the working group. I can remember still one of the very well-known solicitors of the UK bar said, what is not in writing is also writing, he said. He argued. There are a number of areas where there is nothing, contracts are concluded without writing, particularly in maritime law. In case if there is a ship which is to be salvaged, at that point of time, the other ship goes and salvages it. At that point of time, you can't have a written contract because of the situation. So it is a maritime law and practice. They do it, and after that, whatever expenses happen, you need to pay. That is a unwritten contract. And there can be, if you go to ICPIL website, I'm sure you can find what is writing is also not exactly need not be in writing. And technology has actually proved that in recent times. Because there are a number of areas where you don't have anything in writing actually. Now, coming to, and two things, ICPIL recently in 2026, in February, I'm sure Dr. Luther Angreji can say more on this, held a very interesting, very important seminar in New York on the harmonization of all digital trade assets, etc., as part of the ICPIL, working group or annual meetings. Fantastic substantive areas have been covered there actually, where it talked about various, now the first point is subject matter of regulation under contract law or other areas have actually changed. We no longer do it on like what we were doing 30 years ago actually. Today we do it online actually, and there is nothing written about it. And then it happens in multiple jurisdictions. Somebody, my earlier, Professor Manoj Sinha also referred to blockchain contracts. Blockchain contracts there are multiple jurisdictions where actually it can actually stay. Then how do you decide the issue of jurisdiction? Now, artificial intelligence, I'll come to my last point. I have my own reservations about it, but I'll tell you at the end. Artificial intelligence actually brings into the question of matters of interpretation. Now, interpretation, because artificial intelligence actually as it exists today, we don't know what happens tomorrow, because the way it is developing, the way it is going, I don't know where it's going to go. But at least it can, within no time, compile information, interpretative matrix within no time, and can give you the whole bunch of positives and negatives, and then you have the information with you. At the same time, artificial intelligence, that's one of the sort of, tools which could help you in deciding things. That is possible. This is one of the problems, because here the problem is, as in many of these transactions, when it virtually gets into the courtroom or elsewhere, you have information, how do you interpret? Because coming from different jurisdictions, this is one of the issues. We are talking about some 200 jurisdictions with 200 multiple sort of interpretations. I'm sure contract law is not interpreted the way it is interpreted in India, in other countries. Africa may be different, in case if there is other Asian countries, it can be different. You will get all the perspectives AI can actually accumulate and give it to you. How to process it actually? It's a big challenge for all of us. First is to process the information. AI can give you, this, and AI can even process it for you, provided you ask right questions. Google or elsewhere, AI, you have to ask right questions and you get answers actually. And then There is a whole dependency problem which actually going to happen. And then, are you going to solve this problem through this? So this is another challenge, because private international law matters of all this is going to, it's a big challenge, because one is subject matter is changing. It could be intellectual property rights, it could be, intangible assets, it could be tangible assets, it could be online issues, it could be multiple jurisdictions, it could be so many other things. And when it comes to personal laws, where people are located in different jurisdictions and children have a different kind of a nationality, how do you decide all this? It's quite a big mess in my view. So I think this is where I think new technologies are going to be a challenge. And positive, of course, there are positive aspects. I can tell you, positive aspects are that it's going to give you information in no time, but that's not going to solve the problem. Let me come to this is one part of the story, but what we are actually looking at it, with this I will close my speech, we are only talking about some 8 to 10% of the global population actually, who are all dealing with this. There is a vast 80% of the population which actually has no access to some of these things. You see, when you are talking about new technologies, private international law, all these things, you also should think about a population which is not capable of handling this actually. So we forget this aspect, alternative aspects. For example, if you look at internet distribution, there is asymmetry between developed world and the developing world. Africa has many countries do not have that kind of an internet penetration as European countries have. That's why I'm very clear about it, that European model, as we are all referring to, they are quite far away, far ahead of us. In fact, it becomes an imposition, actually. We do not take that model. Because AI, new technologies also are affecting our own employment and other issues. That's a different issue. It's enabler, but at the same time, it is also for a common person, it is becoming a big problem. See, if you give it to me, I still go with put Swami judgment. Even give it to me, even in the airport, I don't go to digital, window. I will always ask for a normal window and then do it even today. Even if you're given a chance to me, I don't pay digitally, still not UPI. I pay by cash. It is good in Mumbai, Maharashtra, because in Mumbai still the auto drivers or taxi drivers say that no, please give me cash. Financial capital of India, I can ask Dr. Luther Rangreji to watch safer. I tell you, Mumbai is the best place. You go, you pay the cash, they'll say, don't give me in digital, give me cash. And they will give you even 50 paisa, 1 rupee coin, they'll give you back. Think about the alternative. Why? It's a financial capital of you. Just go to Mumbai. I'm telling you, it's a great experience. So there is a financial capital. It's happening. The stock market actually trades billions of dollars. But here is a common man who still does not believe in digital assets. I'm telling you. You look at today what is happening, in the country, election mode. Look at that. Is it possible for a common man to go and get a digital copy of these things from somewhere? Can we do it within no time? Our internet's working properly in many of these areas. If you go to a bank, if you go to a post office, half the time the internet is not working. Connectivity is a problem. Of course, we have to improve it. I agree with it. But it's a future. I agree with it. But there is a whole population. Even this aspect also should be taken into account when we are talking about PIL. PIL is Private International Law. It's good to I can refer to World Trade Organization also has come out with a number of conventions. UNCITRAL has done excellent work because UNCITRAL is a more representative body. United Nations body where experts from all countries, at least 56 countries, members elected by the UN General Assembly, sit together, debate all ideas from different countries, whether developed countries are actually done and contributed, and it gives a very excellent drafts, and that model drafts, not binding on countries, which is, I think, a great model to go about. And this reflects, these ideas are reflected in UNCITRAL, working groups, both sides, because you have countries from Africa, countries from Asia, actually sharing their problems. One of the best ways to look at e-commerce problems is to look at UNCITRAL work. I always strongly suggest that, because that's more balanced one. I don't think any other, and models are provided, and it's very helpful in actually implementation, because each country, I finally end up saying that each country is very different. Each country's population is different. Finally, it goes to the people. So obviously, whether are they capable of doing it, and we have to implement it. So that's the problem. India, later in 2000, I remember, we were all working on it. Information Technology Act came. After that, we have not come out with a great, any other important law, unless digital signature issue came, all came through the UNCITRAL models, actually. Even Arbitration, Conciliation Act, and all the dispute settlement issues, and majority, and of course, UNIDROIT, referred to by my colleague again, Dr. Rangreji and other colleagues, that is International Institute for the Unification of Private Law. That's called UNIDROIT. It's in Rome. It is a private, not private essentially, it's an intergovernmental body which also seeks to codify various aspects of private international law, like Hague Conference on International Law. But only problem is these are highly Eurocentric. They actually, we have to think 10 times before actually becoming a part of it. We have to evolve our own strategies and have to work about it. So finally, I end up by saying that, I have prepared some notes, but I feel that it's very important for all of us, including particularly for students. It's a great area. But look at it from a very different perspective. Don't look at it as an excitement, but as a problem, particularly for the common people, how actually it can be very helpful. And I must say, many of our colleagues in the Indian Society of International Law, experts in the field of private international law, have contributed. Professor Gandhi referred to 2006 work, which is an excellent work, which actually we did it for Ministry of External Affairs at that point of time. And some of these issues were actually dealt with in greater detail, keeping in view our own problems. I think with that, thank you very much. And then, yeah.
Thank you so much, sir. So it was sir has covered the various challenges faced in the private international law because of the technology and AI. So it was a very enlightening session, and we are so thankful for sir for sparing his valuable time with us. So now we are going for the individual paper presentations. So I request our student coordinator Likita to introduce our paper presenters.
The first presenter of this session is Ms. C.H. Amrita Gulshan, Assistant Professor at VSL, and ma'am is presenting on the title, Mining the Space, Mining the Law, the urgent need for building a robust legal framework for space mining through the lens of private international law.
A very good morning, everyone. So I'm presenting a paper. I'm presenting the paper on mining the space and mining the law, the urgent need for building a robust framework for space mining through the lens of private international law. So, my paper concentrates on the outer space issues, especially the space mining issue in the outer space, and how private international law can help resolve the fragmented legal situation that we have today. Space mining predominantly is a public international law domain, and there are treaties that deal with space mining. Outer Space Treaty is one of the legal frameworks that we have. However, Moon Treaty specifically deals with space mining, but the unfortunate reality is that most of the spacefaring nations, the active members of space economy, are not even signatories to this Moon Treaty, which makes it a toothless piece of legislation. So with the growing cislunar economy, with the growing space economy, the reality of development of outer space and issues are only they're only going to increase even further. Recent Artemis mission is actually one of the intentions of the Artemis mission was also to find alternative source for water. We are having resources depleting on our earth, the non-renewable resources, even water. We can find an alternative in the outer space, and sometimes it gets cheaper also if we get those resources from outer space in bulk. For example, gold mining, growing gold in lab is actually very expensive if we get gold from asteroids or celestial bodies in a bulk. So there are actually projects that are coming up, such as companies like Carbon Plus. All those companies are focusing on space mining, and their first project is actually launching in 2026. So mining in the outer space is coming to reality, and the interference of the states is coming down, and private players are playing a very significant role. One more thing that we need to keep in mind is that some of the states, such as UAE, Luxembourg, Japan being the recent one, USA, have already started having their own space mining laws, and they started having sovereignty over celestial bodies. So this is something that we need to keep in mind as to how does it even align with the principles, international principles that we have relating to outer space. So sovereignty, ownership is something that is totally dealt under public international law, and although the principles are well established there, the states are not following, and they're not adhering to these principles. Space mining, when we are talking about space mining, private international, let's presume one situation where, next slide please. So this one, it actually shows the previous one. Okay. Anyway, so let us presume a situation where there is an Indian astronaut in an American spacecraft using a Chinese space mining station. Then in case some mining accident happens, in case a mining conflict happens, then which jurisdiction will actually take place? So this is where private international law will come into rescue. So private international law, the paper is divided into three aspects, which is the jurisdiction, classification of cause of action and selection of law, and recognition and enforcement of law and judgments. So first issue is relating to jurisdiction, as to ascertaining whether the court has jurisdiction to even look into the matter. So this is the first and predominant step. Jurisdiction, as per Professor Marchisio of University of Rome, he classifies jurisdiction into two aspects. First aspect is through public international law, where it determines the jurisdiction of a state as to what is the limit of a state's jurisdiction. And the second aspect of jurisdiction is through state's jurisdiction from the lens of the state as to till what extent jurisdiction can apply. So these are the two lenses that we have. One is from public international law perspective as to it limits the jurisdiction of a state, and the other one is state's perspective, where it tells how much state can exercise. These are the two contrasting perspectives, where private international law, where there is an absolute void in this entire phenomenon, in this space as to how to balance it. So and also, according to Professor, it is also mentioned that this concept of jurisdiction is heavily relied on the sovereignty concept. So sovereignty, when we look into the sovereignty of outer space resources, OST Article 1 and Article 2 clearly says that sovereignty, a sovereign claim over celestial resources, celestial mining is not possible. It is considered as common heritage of mankind, right? Province of mankind. However, we have legislations passed by United States of America, such as 2015 legislation, US Commercial Space Launch Competitiveness Act of 2015, under which Section 402 specifically entitles the private person, specifically entitles the US citizen engaged in commercial recovery of an asteroid, that when he recovers a particular mining, when he recovers a resource, he shall be entitled to possess, own, transport, use and sell any asteroid resources. So United States had passed this particular legislation in 2015, but what is the legality of it? Right? Is it even adhering to the international principles? There is also one more case that I quoted, which is Nemitz versus USA, where an individual through online registration claimed ownership of an asteroid. So in addition to this, there is also 2020 executive order passed by by the United States itself, where it clearly mentions Americans shall have right to engage in commercial exploration, recovery and use of resources in outer space. So does a country actually have jurisdiction authority to take up these matters relating to ownership of celestial bodies? So this is something which is definitely not approved by the rest of the countries. So when jurisdiction is one of the factors which cannot be relied on, we have to rely on alternative factors such as registration and nationality. Registration of a space vessel. The concept of registration, such as law of the seas, for example, a floating ship concept, right, which cannot be applied to outer space. Why? Because on Earth, a ship is registered, all the components, everything are made by a country and it is registered to one country. Whereas a spacecraft comprises of various components from various countries and each component belongs to various countries. So here the registration as an alternative factor is also questioned. Next, the second alternative factor is nationality. So nationality is also one factor which is highly questionable in outer space mining projects. Predominantly, most of the mining projects, for example, Artemis, it is a group of most of the nations or countries that are joining together and working on it. So how can nationality be determined exactly? And also the concept of vicarious liability will also come into picture as to in case of vicarious liability, how will nationality be determined? will another country which is liable, will they actually own up to the liability? This raises a lot of questions in insurance claims of a country where, why? Because the space economy is heavily dependent, it's massive economy, everything is very expensive, they're massively dependent on insurance. So these, it is a huge loss in that particular situation. And so even this alternative factor cannot be relied on. Moving on to the second step, which is classification of cause of action and characterization in space mining. So characterization is one thing which is quite interesting, and I would like to emphasize on this, is that characterization of a particular civil wrong, be it contracts or torts, movable, immovable property, based on that particular law will go on, right? So what is when we are talking about mining on earth, if we consider mining on earth, once a resource is extracted from earth, it becomes a movable property. A reference can be made to General Clauses Act, Transfer of Property Act and Registration Act, where the definitions clearly mention that anything which is not movable, immovable property is movable property. But what is immovable property? That property which is attached to earth is what is written in these acts. So when we are talking about mining in space, the very concept of movable and immovable property is questioned. So what are we actually mining? In our mind, we are mining resources which is movable property, but in the eyes of law it is not even considered as a movable property. So how can we determine whether it is lex domicili or lex situs? That is another problem that we have. The same point of view is also there in United States of America, not just India, United States of America as well, where California Civil Code, Section 658, 59 and Section 660 of California Civil Code clearly mentions the same thing, anything which is attached to earth. So that is what is called as immovable property, so which does not accommodate the outer space resources. So there is a need for changing these particular laws. Then the next problem also comes is with proof of fault, which I call it as proof of fault trap. So determining proof of fault is also one of the problems. So in one country, a particular fault may be a contractual breach, whereas in another country, it could be a tortious breach. So there is no uniformity when it comes to dealing with the matters of space, mining in the outer space. Next, the third step is recognition and enforcement of laws and judgments. So when we are talking about recognition, Section 13 of CTC deals with res judicata, which is a common law principle, which is also recognized in UK and other major spacefaring states. When Section 13 is read with Section 41 of Indian Evidence Act, Section 41, which is Section 35 of Bharatiya Sakshya Adhiniyam, which gives a court competent jurisdiction, Section 35 of BSA recognizes the judgment of a competent foreign court dealing with matters relating to matrimony, probate, admiralty and insolvency jurisdictions. But Section 35 of BSA and 41 of Indian Evidence Act failed to accommodate outer space issues. So this is one more thing which is quite problematic into how can we apply Lex 4I.
Ma'am.
Yeah. Done, sir. So I'm concluding, just 1 minute. So my concluding remarks is that if we have to draw a parallel with respect to the liberalization, privatization and globalization reforms, if we have to draw a parallel to mining, environmental law, at least there were certain laws that existed and then technological development did take place. But in space space law, in space mining, the laws are almost absent, both in public international law as well as private international law. That puts us in huge void. So how can we, at least right now, how can we resolve these issues? One is by properly by applying doctrine of renvoi to the fullest, and also by adhering to Hague Conventions, by applying Hague Conventions and also UNIDROIT, like what Sir had suggested. Then also relying on strong arbitration and pre-litigation mediation clauses. One more suggestion that I had given in my paper was that we have to also look into the aspects of ethical mining. Ethical mining and SOPs for ethical mining is something that we must focus on, and that is of high, urgent requirement. Like how we have International Seabed Authority, which looks into the common heritage of man, which looks into the high seas and deep sea mining. Similarly, an authority is also required for outer space mining. I'm sorry for taking extra time. So this is my paper. Thank you very much.
Thank you so much, ma'am. We next have Susamkrita S, practicing advocate, and Srivardhini S from MGR Faculty of Law. Their paper is titled A Study on the Jurisdictional Fragmentation of Autonomous Intent and Re-evaluating Lex Loci Contracts in the Era of Agentic AI. I request the presenters to kindly finish it in 5 to 7 minutes. Thank you.
Good afternoon, respected panelists, esteemed guests, moderator, organizers, academicians, students, and my fellow researchers. I am Susamskrita S, advocate, alongside with my co-author, Srivardhini S, assistant professor. We are incredibly grateful to the VIT-AP School of Law and the Indian Society of International for the Law for this intellectual platform. Today, I stand before you not to just discuss about the artificial intelligence, but to address a growing crisis, a direct ontological crisis in the very foundations of the private international law. So at the very outset, I would like to pose a fundamental question to all you that imagine if an agentic AI which operates, negotiates, initiates, and contract that occurs in a milliseconds, so executed across servers, for example, Chennai, Dublin, Singapore, and involving a manufacturer in Europe and a logistic provider in Chennai. So no human were interfered in this transaction. So if an artificial intelligence system autonomously executed a contract across multiple jurisdictions in a matter of milliseconds, so where does the law locate in the contract? So it is the location of the server or the developer or the deployer, or where there is no place that no longer meaningfully existed in legal terms. So to address this question, our research titled A Study on Jurisdictional Fragmentation of Autonomous Intent and Re-evaluating the Lex Loci Contractors in the Era of Agentic AI. So now let's look at our research objectives and questions so that are aligned with the objectives of this conference. So the conference states the issues, challenges, and way forward in private international law. So the first two research questions regarding the location of the intent and the validity of Lex Loci contractors tackle the immediate issues created by the agentic AI. So we are not just looking at the tech, we are looking at the breakdown of the traditional jurisdictional principles in private international law. And our objective is to evaluate the liability attribution and public policy exceptions under the Hague Conventions, which addresses the challenges of the enforcement. And finally, our primary objective is proposing a unified agency framework, that is UAF, is our answer to the conference call for a way forward. We move just beyond just identifying the problems, but offering a concrete legislative roadmap for the India and the international community. And moving on to the research methodology, we adopted a qualitative and analytical approach utilizing a doctrinal legal research design with a strong policy-oriented focus. Now, let's move on to the title of the research paper. So, we are transition from human to mission concern. So our legal frameworks in India and also in many international conventions and instruments are human-centric, built on a theological premise that only people want to be bound. So in contract law, we have a fundamental principle called consensus ad idem, which means a meeting of minds rooted in a human psychological state. So for example, Section 10 of the Indian Contract Act, which emphasizes the free consent. Though we have Section 10A of the IT Act relating to the e-contract, we still just don't have any contract made by the AI and also the agentic AI. Next, we move on to the fragmentation of the intent. This research paper outlined the crucial framework, that is, the intent of the agentic AI has been fragmented. And this happens by the three things. The first one is the developer intent, and second one is the deployer intent, and third one is the AI operational intent here. So the gap is not just in a regulation, it's in an attribution. So the technology operates in autonomy while the law remains anchored in geography. So here, what is meant by lex loci contractors and why it failed in this agentic AI and private international law? So this led to my next point, that our research, the systematic collapse of lex loci contractors. The lex loci contractors means the law of the place where the contract is made. So here, yes, there are the three principles, though foundational, but when it comes to the agentic AI and private international law, this principle is fragile here. So the first one is an identifiable physical place of contracting, and second one is human communication and intent, and third one is physical acceptance of the terms. So as we all know, the Indian jurisprudence also, I would like to quote a case law, that is Supreme Court in Sriji Traco Private Limited. So the place of contracting and performance determines the governing law. But for our millisecond AI transactions executed everywhere and nowhere simultaneously, there is a legal fiction. And also Section 13 of the Information Technology Act, which tries to anchor the electronic communication to the party place of business, is conceptually inadequate for the autonomous system that are tied to any fixed location at the mission speed level. When we move on to the attribution crisis and the Hague Conventions, so this intent fragmentation creates a central liability gap. So for example, if a traditional agency law holds a principle is bound by the scope of authority, how do we contribute the liability of the AI scope overrun or hallucinated made by the AI or the agentic AI? So we identified a major hurdle that we all know that Hague judgments conventions are there, and in 2019 also it is there. So under the convention, a foreign decree can be refused if it's manifestly contrary to the public policy. And in India also, Section 48 of the Arbitration Act, which the court can refuse award due to an algorithmic due process which is made by the agentic AI or the AI or any system like that. So next we move on to the main thing, that is unifies agency framework. So this leads to our final primary contribution as stated in our research paper. So this is not just an evolution, but a conceptual shift from the human intent to the system-centric justice. So there are three things. The first one is system-centric attribution. So this replaces the lex loci contractors with the law of agentic deployment. So we suggest that every agentic system must be legally registered to be a digital seat. The principal deploys jurisdiction, and the jurisdiction must follow the principal who deploy the agent and not the cloud node. Then the second one is digital audit trial mandate. This can be implemented not only in private international law, but also...
would it be possible for concluding like in 2 minutes or something?
Yes, sir. Yeah. Sure. So, digital audit trial mandate. So, this can be not only implemented in private international law, but also in Indian legislations. For example, so we all know that Section 63 of PSA now guarantees the digital records and digital evidence. So this autonomous decision can be stored in a tamper-proof with the help of blockchain technology, or we have many hashtag like SHA-256. From this we can use and prevent the evidences which is made by the AI or digital thing. And third one is the agentic passport system. So this is a proposed digital certificate containing the developer's ID, the deployer's ID, and thus bound to define the scope of authority. So as I conclude, this agentic AI is an evolution and not a replacement. So the era of agentic AI does not signal the death of the private international law, but rather it's necessary the evolution can be made with the technology. So by replacing the jurisdictional fragmentation with a cohesiveness, accountability driven by unified agency framework, we ensure that the global digital economy remains a space of justice rather than a vacuum of accountability. I would like to conclude with last slide. I would like to conclude with a statement that the law must adapt the speed of algorithms it seeks to regulate, and also in a world where contracts are concluded by machines across the borders, the law must evolve beyond geography and recognize the autonomous intent. Thank you for the opportunity.
Thank you so much. So since we have overshot the time, we would like to conclude the session. So we'll take the Q&A in the next session, if that is, yeah. So now let me take this opportunity to thank all the resource persons, Professor Hegde sir, Pradeep Kumar sir. So it's a great honor for us to have both of you and also Professor Manoj sir in the online to discuss related to the various challenges that we are facing in the domain of private international law, especially in the era of digital technologies. So we thank all the participants and also the resource persons. And before we wind up, I request all the paper presenters and the student coordinators to kindly come to the stage so that we can have a one group photo session. Thank you.
Law in the era of new emerging technologies, issues, challenges, and the way forward. As we begin the session, I respectfully invite our distinguished keynote speakers and our session moderator, Pranav sir, to kindly take the stage. Dr. G.G. Hegde sir, Associate Professor of Law and Faculty in Charge, Ministry of Commerce, Chair on International Trade Laws, National Law School of India, University, Bengaluru. Stelina Jolly, Associate Professor, Faculty of Legal Studies, South Asian University, India, and Dr. Veronica Ruiz Abu Naim, Professor of Private International Law, University of Edinburgh, who is joining us online in shortly. And we are truly honored to have such eminent scholars with us. Thank you. It is now my pleasure to introduce our session moderator, Dr. Pranav Anand Oja, Assistant Professor at VSL VIT-AP School of Law, whose expertise will guide us today. I now request Sir to kindly take over and continue with the session.
Good afternoon, everyone. ठीक है. After lunch, I will not trouble all of you. That is why I started this session as soon as possible. So with sir and ma'am permission, I'll begin this session. Let me introduce our first keynote speaker, Dr. Govindraj G. Hegde, sir. Sir currently serves as an Associate Professor of Law and Faculty in charge of Ministry of Commerce, Chair on International Trade Laws at the National Law School of India University, Bangalore. Prior to joining the NLSIU in April 2002, Dr. Hegde was associated with the ICPIL, New Delhi, where he served as Assistant Professor and Course Coordinator for the Postgraduate Diploma in International Trade and Business Law at the Indian Academy of International Law and Diplomacy. He also contributed to academic scholarship as Assistant Editor of the Indian Journal of International Law. Sir's area of specialization include international commercial transaction, international trade and investment law, biotechnology and law, and private international law. His work reflects a great engagement with both theoretical and policy-oriented dimensions of international legal framework. He has held several significant advisory and government roles. He is a member of Genetic Engineering Approval Committee under the Ministry of Environment, Forest and Climate Change, Government of India. He was also the part of Indian delegation to the open-ended ad hoc working group meeting held in Montreal, February 2007, which addressed issues of liability and redress under Cartagena Protocol on biosafety. He has also served on the consultative group on biodiversity issues under the same ministry. His academic contributions include publications in reputed forums such as Asian Yearbook of International Law and Indian Journal of International Law. He has also played an important editorial role as faculty advisor to the National Law School of India Review and as chief editor of the National Law School Journal. Dr. Hegde's academic excellence is further reflected in his selection as a fellow of the Hague Academy of International Law in 2004. Sir will speak on the issue of the impact of decentralization and anonymity in digital transactions on conflict of laws. We welcome you, sir.
Thanks, Dr. Pranav. Good afternoon. It's a bit difficult to address the audience just after a full meal. The title for this session, anonymity and then conflict of laws. These are legally bit difficult expressions to follow up. But as far as our readings are there on the question of anonymity, what we sense is that a kind of ghost which is lurking behind the subject matter called private international law, the digital economy. Sometimes it is seen, but most of the time it is not seen. That is the kind of scenario we have in front of us. In my 13 minutes address henceforth, I would like to follow in the following manner. I deal with some of the fundamentals in private international law, rather the approach to the study of private international law, basic principles established. And from there, I would like to travel to the area which is which are choice of law issues, applicable, and then jurisdiction issues applicable to digital economy, and then conclude. Sometimes it is jokingly said, private international law is neither private, nor international, nor law. The word private is misnomer because it involves public policy matters as well. The word international is not international in the sense it is international in the expression public international law, because the subject matter covered in any private international law convention is addressed to private individuals or corporate bodies. And then the third expression, law. What is law? Our understanding of law means there must be some statute, isn't it? But private international law is a body of statutes. It's a body of loosely used word called legal principles. And hence, there is one more expression which is used that is like private international law is neither private nor international nor law, like Roman Empire, who was neither Roman nor empire. So that was the kind of situation we confront with when we address issues in the subject of private international law. Basically, in the morning, there was a paper presented on, which draw our attention to one of the fundamentals of private international law, characterization or classification. You go to any legal system, that legal system must have two important incidents. One, a category called legal category. One group of subject matter is called legal category. The other one is connecting factors. Students studying private international law would do well when they master these two expressions in any given legal system. An example for legal category. The legal question which may arise in the context of movable property in a cross jurisdictional sense. What is the connecting factor? The connecting factor is lex domicili, law of the law of domicile, according to which the claim will be decided by the court which has seized of the matter. The opposite of movable property is immovable property as a legal category. Then the connecting factor, which is almost understood in its right spirit in most of the legal systems, is the lex situs, the place where the immovable property is situated. These two are just the example, but no legal system can give you an entire list of its legal category on the one hand and the applicable private international law, connecting factors. So this is the sum and substance of private international law in general. Then how do we understand the applicability of the well-established private international law principles in the area of choice of law and in the area of jurisdiction? The given theme, the anonymity, and then the conflict of laws. This expression raises a particular point, whether we have to deal with the present day circumstance or legal questions that have been thrown up before the international community, which is comprised of states, then, or we have to invent new private international principles. One option is you modify the already existing private international law principles and then decide the legal issue. The other one is in the play as against modification of the already existing private international law principles in resolving the conflict, cross-border conflict. States may endeavor to identify, they may endeavor to provide a new private international law principles. I belong to the traditional school of private international law learners, and I most probably align with the first. How to apply the well-established private international law principles in choice of law issues as well as in jurisdiction. Both are applicable to digital economy in the end. I refer to characterization and classification. That is the first stage of arriving at a proper understanding of private international law subject. Any problem, any difficulty faced, or any indecision in characterizing a particular issue, like there is a cause of action, how to characterize this, whether it is a breach of contract or it's a tort of negligence. Depending upon that, you have to decide the connecting factor. So if it is breach of contract, legal remedy is something. If it is tort of negligence, legal remedy is something else. So that is the significance of the subject matter called characterization or classification. How to take a bundle of facts which has given rise to cause of action under one category or the other category. So coming to the second stage of my address, I deal with the well-established private international law principles in conventional understanding. As far as choice of law issue is concerned, sometimes it is customary to deal with jurisdiction first in private international law discourse, then get on to choice of law issues. As far as jurisdictional issue is concerned, some of you must have studied private international law. In a world system which is comprised of states, each state has its own legal system. And in a country like, in a country, a proper word to use here is country, not state. In a country like United States, there are federal states. Each federal state will have its own private international law mechanism. Something similar in Australia as well. In Canada as well, there is Quebec and outside Quebec. So private international law system works in a particular legal space within a federation. As far as India is concerned, there is a single legal system called Indian legal system. There is no such legal system called Andhra Pradesh legal system for the purpose of private international law. In matters relating to jurisdiction, being a common law country, India has followed English common law principles. Time doesn't permit me to go through the developments that had happened in Europe, like Brussels Convention first, and then the Brussels Regulation. In the field of choice of law, Rome Convention first, and then the Rome Regulation. There is Rome II as well, that deals with tort matters, cross-border tort matters. As far as, speaking of jurisdictional principles, private international law in common law, as the Indian legal system has understood, deals with three types of jurisdiction. One is actor sequitur forum re. That means when the defendant is within the territorial limit. This is one of the foremost and the most powerful way of exercising jurisdiction. Reasons are well known. When the defendant is within the territorial limits of the state has every authority. State means the court. Enforcement agencies have every authority to summon. Nobody can question that. Actor sequitur forum re, territorial jurisdiction. The second one is consent-based, which is divided into several divisions. Consent may be given by the state when it is a party to an international, private international law treaty. But rights and obligations which percolate under the treaty are addressed to individuals or corporate bodies. For example, Carriage of Goods by Sea Act. India is a party to international conventions. India's enabling legislation has given effect to the Hague Warsaw Convention, Hague Protocol, and then the Montreal Convention as well. This is the second type of exercising jurisdiction. The third one is assumed or exorbitant jurisdiction. This is controversial, not only in private international law, in public international law as well. Let me not get into the interface between private international law approach to assumed or exorbitant jurisdiction and the general international expression extraterritorial jurisdiction. All in all, private international systems accept the first two types of exercising jurisdiction. But the last one, being controversial, there is no unanimity. Although courts in most of the powerful countries, as well as not so economically powerful countries, even in theory, they can exercise exorbitant jurisdiction. For example, India, Section 20 deals with jurisdiction in cases of cross-border transactions. So reading that provision along with the order, one can say that if there is a connection between India and the overseas defendant, Indian court can exercise exorbitant jurisdiction provided it has everything in its procedural law to serve the summons upon the defendant. Professor Hegde referred to this matter in his address just a while ago. So given the significance of the rather non-applicability of assumed jurisdiction in conventional private international law principles applicable to jurisdiction, one can see the problem in arriving at proper conclusion as to jurisdiction in international sense. So jurisdiction in international sense is an expression used only to the first and second category of jurisdictions. The third category is a controversial candidate, but how states position themselves is a different question altogether. This is the this is the first way in which I can express the conventional wisdom which states have expressed while exercising jurisdiction over cross-border transactions. So what I have to emphasize upon here is the concept of international jurisdiction. How this principle can apply with respect to digital economy when courts exercise jurisdiction in an anonymous personality. You know, we don't know whether AI, artificial intelligence, is considered as a legal person. What is the Indian law as far as this issue is concerned? Private international law moves ahead only with the concept of legal personality. Conventional private international law recognizes natural persons and corporate bodies as having legal personality. But whether AI, does it have? In 2007, UAE has legislated and it has conferred some status of legal personality upon AI systems. But talking about India, I think I would raise the question, what are the policy implications if India has to embark upon a full-scale policy framework applicable to AI that may have far-reaching implications for cross-border transactions? The next one is choice of law and its applicability to digital economy. As I said earlier, digital economy is amorphous one. There are transactions. A transaction may have originated in country A, but the transaction may have completed in country B. But there are intermediaries as well. So that is the complex web. AI system is a complex web. If it is natural person, you can very easily determine the territorial jurisdiction or even consent-based. But how do you arrive at that decision when they are applicable to anonymous entities such as AI system? Unless a proper policy and legal framework is put up by the state, concerned state, it will be difficult for the stakeholders who are involved in the settlement of international or transnational, rather cross-border trade disputes or cross-border family issues as well. There are two ways of applying private international law principles. I think I have a couple of minutes. Yeah, I couldn't follow the time frame. But as we teachers, we are accustomed to 1 hour of discussion. Anyway, conventional PIL principles applicable as per common law, English common law as understood in Indian legal system. The proper law of contract, express choice, employed choice, and the most real and closest connection. Theoretically speaking, employed choice is debatable, but at least if express choice is not there, then you can combine the employed choice along with most real and close connection test. But English jurisprudence is quite attractive in this context as well. There are two schools of thoughts. Let us leave this question aside. But there was an important modification made to the concept of proper law of contract in the European context. The Rome I first, and then the Rome Convention, and then the Rome Regulation I. Both of them dealt with choice of law issues applicable to cross-border transactions. They brought in this new concept called characteristic performer of a contract. like in a sale transaction, overseas sale transaction, who is the characteristic performer, whether the seller or the buyer. So without any dispute, seller is considered as the characteristic performer. And hence, if other conditions are met with, it is not that Rome Convention or the Rome Regulation, they dumped the traditional principle of determining proper law of contract, which refers to express choice or more real and close connection test. But then how should one apply the concept of proper law of contract to AI system, which has influenced the course of international commercial transactions? So these are the basic tenets. Now coming to the AI system and its special applicability to the digital economy. What is AI? The theory and development of a computer systems. It's a huge web. Even as an ordinary person, it's very difficult to understand how does it work in actual practice. Maybe we need, a lawyer may need a scientist, a person who is well versed in computer science. But it is defined as the theory and development of computer systems able to perform tasks normally requiring human intelligence. But have we come to a stage where AI can completely replace the way human beings perform in cross-border transactions? It's a serious question which is posed to the policymakers. And then legal personality, unless any policy thinking on the working of AI system and its implication on, for example, India's private international law, whether Indian law recognizes AI as a legal person. It's very easy to understand legal personality of natural persons, even body corporates. But how to determine the legal personality of artificial intelligence system? So there is a legislative development, rather the policy development and legislative development. I have given the example of UAE. In Europe, it's in the forefront of inventing more and more on the subject of AI and its implications for transborder relationships, particularly contractual relationships. It's not an easy question to answer. Policy, where to put an end to the legal personality. As we have studied law, in any legal system, not all subjects have similar rights and obligations. So any state which is moving forward in developing a pull-through policy framework and then the legislative framework, it must first decide on the question of what kind of legal personality that legal system has to offer to AI system. Do I have time? Just one minute. The last question is, that is the last function of private international law, recognition of foreign judgments. As far as Indian law is concerned, we don't have a private international law statute as such, but we have certain provisions in certain Indian laws, and then court rendered judgments to define the concept called Indian private international law. It is also a kind of amorphous nature. But does India require a private international law statute? If not on all subjects covering covering India's position in cross-border transactions, at least with respect to AI-sponsored, AI-influenced international commercial transactions. So, limits of legal personality of AI system is a subject matter which is very fluid as of now. I mean, one may read the Niti Aayog's position paper on AI system. Well, the digital age has complicated the way people think and the way people trade with each other. And I will not deal with family relationships, which is also part of larger subject called private international law. For practical purposes, trade in goods, trade in services, it is quite understandable. But with AI entering the field, it's not easy to distinguish between these two types of goods being transported from one country to the other country. The last issue, as I said, recognition and enforcement. what is AI, and then how it can it can influence the course of judgment, course of enforcement of foreign judgments. Section 13 of CPC and Section 44A. These are the two provisions. But in due course of examining the claim under both of these provisions, a court may have to make use of AI system. Suppose the concept of AI system, the way AI system has been legally pursued by India, is not tenable to is different from the concept of legal personality accorded to AI in another country. There could be a conflict. So it will negatively impact upon the enforceability, recognizing and then enforcement of foreign judgments in India, and adversely and inversely, Indian foreign judgments may not be recognized and enforced in foreign countries. All in all, subject of private international law, which has been in vogue for several decades in this country, at the end of the day, we have to ask the question whether Indian private international law subject is prudent enough to accept the developments, modifications sought in other parts of the world, particularly European. China is also in the forefront. Germany is another country. South Korea is also in the forefront of, it has taken lead in this area. So India has to ask a prominent question: how should the public policy understood in India's private international law allow the functioning of AI-related transactions which have significant foreign elements, and when they come up before Indian adjudicators, how to address them. So I put a small question here: should Indian policymakers, Indian courts rethink about the narrower concept of public policy, that is Indian private international public policy, which is distinct from public policy in domestic public policy? Whether time has come to think in terms of balancing the policy perspective with that of substantive legal principles applicable to the interaction between AI systems and cross-border transactions involving India. I thank my co-panelists. I think I have taken much time. There are other subjects to talk about. Maybe if I receive questions, I try to answer those questions as per my understanding of the subjects. Thank you.
Thank you, sir, for this insightful conversation. Now I would like to introduce our next speaker, Dr. Stelina Joly, ma'am. She will speak on the issue of legal complexities in enforcing smart contracts and AI-generated agreements across jurisdiction. Before I call her, let me introduce Professor Stelina Joly to all of you. She is a senior associate professor at the Faculty of Legal Studies, South Asian University, New Delhi. She is also a visiting senior research associate at the Center for Private International Law in Emerging Countries, Johannesburg. She is an affiliate scholar at Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund, Sweden. Dr. Joly is a Fulbright scholar. She was selected for the International Visitors Leadership Program of the United States Department of State. Her research focus ICPIL Academy of Environmental Law for South and West Asia. She is an executive council member for the Asian Society of International Law. She sits on the editorial boards of the Yearbook of International Environmental Law at Oxford and Climate Law at Brill. Please welcome Dr. Stelina Joly.
Warm good afternoon to all of you. Distinguished guests on the dais and off the dais, colleagues and my dear friends. Firstly, let me thank Professor Banerjee for inviting me to this academic event. And when he first talked to me, my first reaction was that, okay, the topic is private international law, which we don't see much of a conference, focusing on. So thank you very much. Okay, so thank you very much for that. So from morning, the inaugural session, and after that, I'm sure you must have heard about the term private international law and how is it actually different from public international law. And you heard at least multiple times the term jurisdiction, choice of law, and recognition and enforcement of judgments. Of course, my talk also will come from that particular aspect. But before that, see, when you talk about private international law, I'll just ask you to examine your day-to-day life from morning to evening. See, knowingly or unknowingly, we all are engaged in transaction which has got some amount of cross-border. See, I don't belong to the Instagram age, but maybe the Facebook, but when you post something on Instagram, somebody else, maybe in US, UK, Germany, anywhere, they see that, or you put something which is objectionable or defamatory to somebody, that's where the cross-border connection that comes. So similarly, when you go for a trip, you meet with an accident, or you make an international travel, these are all in our day-to-day life experience. We as a private individual has a cross-border connection with some jurisdiction. So whenever individuals deal in their private capacity and having some sort of cross-border aspect, the private international law comes into operation. And you also heard about 3 issues which is important in private international law. For instance, when you study contract, you study a lot of substantive principles like what is an offer, what is an acceptance. But in private international, we don't need actually get into these nitty-gritties. We try to look at jurisdiction, choice of law, recognition. But what exactly is it? If you remember in the inaugural session, Advocate Pradeep Rai talked about Aishwarya Rai. So I'll start again from that. You just imagine Aishwarya Rai, she's an Indian national. She enters into a contract with, let's say, some agency, the talent agency, whatever, the event management company who is based in UAE for a performance in UK. So you have in this example 3 jurisdictions. Aishwarya Rai, she is from India, so she's connected to Indian legal system. The contract, it's a performance which is to be performed in UK. So it's entirely a different set of legal system. The company who is also part of this agreement is also based in UAE. So you have 3 different legal systems, individuals somewhere connected, UK being the place of performance. So in case if there is an issue with the contract in terms of performance or somebody breached, let's say she refused to perform her part of the contract. So the company wants to file a suit. That's the basic question in any legal breach of an issue. So that's where the private international issue comes, because it's not a domestic case. There are 3 legal system comes. The place where Aishwarya Rai belongs, the place where the contract has to be performed, or even the agent through which this entire contract was drafted or the contract is signed, right? So one of the fundamental questions the private international law decides is that where do you file a case? Even if you file a case in India, the Indian court has to see that, can I simply apply the Indian contract law? Because there are other legal systems involved. So I need to make a choice. So even after a judgment, I need to enforce that judgment. So private international law deals with that. But this example, it is very easy. As Dr. Luther Engreji in the inaugural said, private international law principles are essentially very territorial in nature. The place of performance, that's UK, you locate that territory. The nationality, Aishwarya Ray's nationality, India or residence, you connect that. So its connecting factors in private international law is territorially anchored. So now the entire theme of this conference is that the new technologies like blockchain contracts, the cryptocurrencies, and artificial intelligence generated contracts, will it pose a challenge to private international law, or it may or may not? So this is what exactly. So I'll also start a caveat to that. I understand private international law, but I am not a very technically sound person to understand the nitty-gritties of, when we talk about a smart contracts or a cryptocurrency. So I'll start with an example. So you can differentiate this example from the one which we took it as the basic example of Aishwarya Ray to understand that, will this issue is different from the one which we just saw. So for instance, if an Indian buyer, person who is residing and staying in India, he purchases a certain digital assets, which the digital assets are through a blockchain based smart contract, coded and developed by somebody as a developer in US. So you have two legal systems getting already connected, and these nodes of which are distributed globally. The payment is through cryptocurrency, and then the contract self-executes. So you have a typical example of a smart contract, and there is a bug that creates a certain loss. So this example is a slightly different and complex from what we just saw, but the questions remain fundamentally, it's the same. In case of this issue, which court will the case has to be filed, which set of law should be the applicable one, how does this contract or this issue will be enforced. So we'll just try to look at a certain scenario. But before that, I would also want you to understand a fundamental fact. When we talk about smart contracts, every smart contract doesn't automatically become a legal agreement. So there are three category of, perhaps maybe there are multiple category, but I will just look at three categories of smart agreement or a smart contracts which you take. The first one is a smart contract, but it is attached to a main contract. The second one is a fully automated smart contract. The third one is an automated one, but it is mostly used as a tool, a kind of a tool scenario where without maybe any legal. So for instance, if I take the first category, let's assuming that there is an insurance contract. That's a agreement entered between two parties. There is a natural language, it's a insurance contract. But attached to that insurance contract, there is a smart contract part. So which can self-execute, which says that if there is a weather-related associated, so the payment will be released. So you have a smart contract which is attached to the main contract. So if there is an issue, what the courts are actually looking at is not just enforcing that particular contract, the smart contract. What the courts are actually enforcing is the main insurance contract. They will look at the language to see what the parties intended as the jurisdiction, choice of law, and enforcement. Here also, I would like to mention that in terms of private international law, especially with regard to contract, the jurisdiction and choice of law is become much easier. The reason is that unlike a lot of traditional field, party autonomy is understood and well recognized across jurisdiction. So when I say party autonomy, so if I enters into a contract, like the same example of Aishwarya Ray, and when she enters into a contract, she has the freedom, the parties, to choose which court I will file a case. So you have a party autonomy in terms of jurisdiction, You also have a party autonomy in terms of deciding, in case of a dispute, I'm going to apply the French law or the Kenyan law, whichever law. So the parties have the autonomy. So things become much easier in terms of, contract in terms of private international law. So the first example which I talked about, the smart contract embedded as part of a main contract, the issue will not be so difficulty because the courts will still look at the party autonomy, party's intention, and apply the traditional principle of private international law to decide. The second scenario can become a little complex because that is a fully automated one, where, for instance, some user wants to buy a cryptocurrency or send a cryptocurrency, and the contract, the self-executed contract, generates that token return, and the digital assets is created. So there is no human involvement. That is where the scenario can actually become tricky, because it doesn't have a specific location to understand that. So even in that scenario, my understanding is that the courts across the world will look at, if at all, even if it is in a code, can we find out an intention from the language? If they can find out an intention, they will definitely go for that intention, even if it is embedded in the code. The last scenario doesn't actually create any sort of a legal obligations because it is normally used for an internal purposes of the company's transactions and all. It doesn't really have a legal issues. So my assumption is that I strongly believe in the functional element of a domain. So I believe that private international law has that innate ability to functionally evolve to this particular scenario. But of course, this is also an opportune time. But there is one instances I can see a lot of challenge and differences. See, in a traditional contract, when I say I have the ability to maybe even prevent somebody from breaching, so I can take maybe preventive action. And even if somebody breaches, I do have a remedy in terms of specific performance restitution. But what happens in the case of a smart contract is that already the contract, the bug itself executed, it sometimes becomes irreversible. So for a court to execute that, the traditional remedies will not work because there cannot be any restitution, there cannot be any specific performance because it's already over. The court never comes into the arena, its court comes into the arena only after the scenario is over. So that is where the real challenge to the traditional, the enforcement part of it comes. So how is it actually the different legal system has looked at? India, of course, has not looked at specifically. But if you go by the evolutionary development of India's jurisprudence, electronic contracts are definitely valid. I'm sure the court will try to find the human intent involved in the smart contract also. But if you look at the United States and UK development, especially UK, if you look at it, UK Jurisdiction Task Force legal statement on crypto assets and smart contracts, they specifically recognize it. They recognize the property dimensions of it. Similar is the scenario in United States. But even with the absence of the Indian legal system, I do not look at it as a handicap of the Indian legal system, but I'm sure that when a case scenario comes up, we are going to look at the different legal developments and the spirit of the private international law to decide the cases. Now, I will also briefly touch upon the artificial intelligence generated contracts, which I look at it slightly different from the smart contract, because when you talk about the smart contract, there could be a scenario where it is completely alien to the human. It's generated as self-automated, where the human element is definitely missing. But most of the AI generated, for instance, even if I ask ChatGPT to generate a contract, ultimately, it is for me and the other party to decide whether I want to sign the contract or not. So the contract is still signed by two humans. unless and until that AI self-execute that or hallucinate, as Dr. Hegde says. Otherwise, it is still an agreement between humans. The traditional principles of private international law will still be applicable. Yes, the challenge will be in terms of interpretation. I think Dr. Rengreji in the morning did, touch upon that. What happens is that when AI generate, I'm sure many of you for exam research, you are actually using. Sometimes AI can definitely make mistakes. AI can quote the legal provisions, interpretations differently. AI can mix multiple legal provisions. So sometimes the uncertainty and two legal provisions in the contract itself can clash. So if the parties to that agreement are not really smart enough to understand that there is a conflicting scenario, this is a right or wrong positions, when they finally comes to the implementation stage, it can result into complexities, because the court may say that, no, these two clauses cannot stand, the contract itself is void, right? So I look at the AI-generated contract slightly on a different parallels. The problem will be in terms of what AI actually has generated and whether the parties has that due diligence to really look through the contract and see that this is the legal provision to which we, agree to it. So that definitely is up to the parties. So the last point I want to highlight is that I believe, as I said, the functional ability of any domain to evolve. So I look at it as an opportunity for private international law. I'll actually take a little bit from what Professor Hegde said. He did talk about the caution with regard to the technology and other. He also talked about the digital divide, the technologically divide, and I completely agree that. But I don't subscribe to the view that, we need to be averse or cautious in terms of using the technology. But what I want the global South and India and South Asia to understand is that similar to public international law, private international law is also very Eurocentric origin. Even when I say it's a territorial, the connecting factors are domicile, these are all colonial creation. Who has told us that domicile, nationality, the place of performance should be the connecting factor? It is the Eurocentric. We have inherited the colonial. So this is an opportunity for us that if we want to challenge the Eurocentrism involved in the Hague Conference and other conferences, do we have an alternative in terms of the legal pluralism? And private international law automatically doesn't mean that everything has to be harmonized and codified, right? So that is where this is an opportune moment that country like India, we do have a large technological base. So this is an opportunity that Indian courts and the policymakers should really sit down to see that what is the connecting factor which we think which is the most favorable to us, and we should try to develop that. Otherwise, what happens is that we will eventually rely on the European Union framework or United States framework, and after 10 years, we will sit down and say that the entire private international law domain is still Eurocentric. So I believe that this is an opportune time for the Global South to articulate what else could be the alternative connecting factor, or even if they agree to the connecting factor which is suggested, we need to have that participatory voice. So I'll stop there, and thank you.
Thank you, ma'am, for your present address. Now we have our third speaker, Professor Veronica Ruiz Abau-Naim. Please forgive me, ma'am, if I have incidentally butchered any part of your name. Ma'am, Jolly ma'am has ended with Eurocentrism and pluralism. Our next speaker, her central theme of the research is to bring in diversity into private international law. So she holds a personal chair in private international law at the School of Law, University of Edinburgh. She completed her Juris Doctorate and her MA in law with a specialization in law of integration at the Catholic University of Uruguay. She then came to Edinburgh, where she earned her LLM in commercial law with distinction and her PhD in 2008. Like I said, her scholarship is defined by one core conviction that private international law must engage with legal, cultural, and methodological diversity. From 2014 to 2017, she led the PILIM project, which is Private International Law and Development of Integrated Markets, across regional collaboration with University of Buenos Aires and University of Belgrano. Her interdisciplinary approach spans maritime law, public international law, international commercial arbitration, and international civil and commercial litigation. Ma'am will speak on the issue of private international law and sustainable development. Please welcome Professor Veronica.
And I hope everybody can hear me well.
Yes, ma'am, we can.
Excellent. I am delighted to be here, and thank you very much for the organizers for this invitation. There's a little bit of echo at my end, but I hope that does not affect. Just let me know if at any point things don't work. To think about how we engage and how we aim to transform, the reality we live in, also from private international law. So in that sense, this work on private international law and sustainable development very much addresses that tension between the global south and the global north that is central to the sustainable development agenda, and aims to somehow take the asymmetries and imbalances that are part of the global scenario we live in and tackle them from a private international law perspective. So this is central to the agenda of private international law and sustainable development. Having said that, I think I can start with a brief setting the scene about the triple economic, social, and environmental crisis that we live in. The response to that to the Sustainable Development Agenda, I'm sure, is an agenda that you know well, that it's been around since 2018, but also refer a little bit to the background to that, so we understand how we came into having this global plan of 2030 agenda. And then particularly focus on what private international law can contribute to strengthening the plan of action of the SDGs, and what are the challenges. And I like to get to the challenges, particularly from a Global South perspective. So as in the introduction, it was mentioned, I'm originally from Uruguay, so I'm South American, and my training as a lawyer was very much in Uruguay, and I work as a shipping practitioner back in Uruguay, but I've been in the UK for 24 years now, quite a long time, and in that career, I have continued to engage very much with not only scholarship, but also practice in the Global South across the world, not only in Latin America, from where I am from. So in that sense, I do think it's key that we engage with that global perspective. And when we think about private international law, I think that's what comes to mind to me. So I'm going to kind of start from the sustainability concepts and how we came to the Sustainable Development Agenda. It is important to understand that when we talk about sustainability and when we talk about sustainable development, we are talking about not only environmental sustainability, but social and economic sustainability. So what actually sustainable development as a concept that actually appeared it's a very long-standing concept that appeared in public discourse in the 1970s and became popularized in 1987 with the Brundtland Report. That concept brings together social, economic, and environmental sustainability. And there's no doubt that environmental sustainability is the one that came in a way later to global plans such as the Sustainable Development Agenda. If we look, for instance, as the Millennium Agenda, which was the agenda, the UN agenda that just preceded the 2030 agenda, from 2000 to 2015, we had the Millennium Agenda, which very much focused on developing countries and very much on social and economic development. So what the Agenda 30 agenda brings in is that environmental sustainability integrated to social and economic sustainability. And I think it's really important in the context of looking at technology and the theme of your conference, because part of this is understanding that the three of them, social, economic, and environmental sustainability, need to be tackled in an integrated manner. And unless we think about these three components of sustainability, we kind of will find to actually make any transformational changes. So, in relation to private international law, the agenda itself, the 2030 agenda, it has 17 SDGs. As you know, none of them mention private international law instruments, private international law mechanisms or techniques or methodologies as we know about them. The agenda is completely silent in relation to private international law. There are several public international law instruments that are mentioned throughout the agenda. And there are, in that sense, the regulatory aspects of public international law come across very often in the targets and the indicators. So as you know, the agenda is not legally binding. It proposes 17 objectives that are themselves organized in specific targets, and the targets are measured in accordance with indicators. These indicators are developed nationally, and in a way, this operates very differently in different countries in the world. But in that structure of strengthening the plan of action, the agenda itself is completely silent. So that was something that very much motivated our work. And when I say our work, I refer to this work that I mentioned before that had its first output in a book called the transformative side, the private side of the title is The Private Side of Transforming Our World. It's a book that was published in 2021, and it's an open access book, so everybody can actually see it online. This book was put together by 17 scholars from around the world, with Hans van Loon, Ralph Michaels, as myself as the editors, looking at each one of the SDGs private international law. And the reason for doing that was very much motivated on the fact that the agenda itself is silent, but there are so many ways in which private international law interacts with the objectives. There are ways in which private international law contributes to the objectives, but I think very importantly, it is important to gain awareness also on the ways that private international law can obstruct or hinder progress towards development. And I think this is where it is crucial that we take an approach in a way that is objective about the limits of a discipline such as private international law and the limits of what private international law instruments can contribute, but also try to think broadly and try to think with an open mind in terms of how can we rethink private international law and make a greater impact. So the book looks at not only extant rules of private international law, but private international law potential. And that is, again, where I think a global South perspective is crucial to take that potential forward. Going back to what was mentioned before about, the fact that we think about private international law from its early origins in Europe and in developments across the world, and the region where I come from, South America, has traditionally been very active in developing its own framework of private international law. But still we have certain ways of doing things that have, and we have to be very clear about it, have in many scenarios contributed to the harmful practices that are very much at the moment unsustainable. So when we think, for instance, about the way that global supply chains operate, and when we think about the climate crisis, and when we think about who are the bigger emitters of CO2 emissions, we think about also the infrastructure, the legal infrastructure that has enabled that. And of course, that enablement has a lot of positive elements towards development. But in instances such as the abuse of party autonomy by players can be seen as something that at times have generated a race to the bottom in terms of regulatory standards rather than a race to the top. Or, for instance, if we think about specific rules of jurisdiction and the way that jurisdiction sometimes is channeled towards there are centers of jurisdictions in the global north, and I have to say the UK is well known to attract that level of international litigation. That channeling to a litigation in the global north, it has very important and positive consequences in terms of access to justice, but it also may be depriving the global south countries from developing their own legal infrastructures for international litigation. So I think it is very important to take a balanced approach and understand that many of the methodologies and techniques in private international law have the potential to be used in a way that supports and promotes the objectives of sustainable development, but also can be in the same way obstructive to that. So for thinking about these problems or these challenges that comes to us in terms of private international law and sustainable development, we think about private international law and its three main functions. So this is something that we developed together with Ralph Michaels and Hans van Loon in that book, in the introduction to that book, but it is something that we have continued to work from. And I have to say, this is an ongoing project. We launched it with that book that I mentioned before, but we had an Asia regional project with a conference in China with participation of colleagues from India as well in that region. We also had a Latin American regional project, and now we are working on an Africa regional project. So in that sense, the project is an ongoing project. We moved from the global approach, particularly to the research, to a more regional approach, because I think the differences of how sustainability and sustainable development are tackled in different regions merit a regional approach also at the research level. But with that caveat, going back to the coordination, facilitation, and regulatory function, these three functions that we conceptualize in the work are very important to bring about the potential of private international law. So when we think about private international law techniques, clearly we think about coordination. Right? So coordination between legal systems is what private international law does best, and is what we are known to see when we think about private international law instruments. We think a means of coordinating the differences and the diversity between legal systems. And that coordination is key across the board, and it will continue to be key. The other function of private international law is facilitation. So this comes across very clearly when we think, for instance, about party autonomy that I was mentioning before. So private international law enables the effects of private law across borders. So if we think about specific private law mechanisms, let's think about, for instance, contract law that is as such in terms of domestic legal systems conceived to have effect in one jurisdiction, is enabled, or kind of the transnational effects of that law is enabled by private international law mechanisms such as party autonomy and the possibility of the parties to a contract to choose the applicable law in an international contract. So in that sense, that enabling, that facilitation is something that is also very visible in relation to private international law functions. The regulatory function, however, is probably the one that it has always been there, but not necessarily so obviously, and particularly not so obviously to the ones who are not familiar with private international law. So possibly the fact that the UN 2030 agenda is silent in relation to private international law instruments and methodologies is because it doesn't come across as obvious that private international law deploys a regulatory function. The typical example, and I have to say the example well known is a European example, is the rule on applicable law to environmental harm. So, for instance, in the European system, it is possible for the parties to the litigation to choose between the law of the place of the harm or the law of the place of the damage, depending on what is more, so the claimant has that choice depending on the standards, on the environmental standards, in the difference between these two possibilities in terms of applicable law. And that is considered to have a very clear regulatory function in the sense that it actually allows for the claimant to choose the environmental law that has the stronger environmental impact. And I think this is particularly interesting in relation to jurisdictions like India that still uses the double actionability rule when it comes to applicable law in relation to torts, right? So in that sense, I think we have an example of a private international law rule that has a clear regulatory, not only a regulatory objective, but a regulatory impact, but also systems like where that regulatory impact somehow is not so prominent because the methodology used is still coming from a different time where private international law at the level of cross-border harm or tort or delict in other jurisdictions was not so developed. So I think that is a particularly interesting development. The other one, and I am running out of time, but I wanted to mention because this is particularly something that I have worked quite a lot in my scholarship, is the we tackle jurisdictional challenges. So again, when it comes to jurisdiction, SDG 16, which is the SDG focusing on access to justice, is a key sustainable development goal of the agenda. So we know that access to justice and access to transnational justice is a transversal goal. It is very important to obtain the objectives or move towards the objectives of all the other sustainable development goals. But we also know that when it comes to access to justice is not only super important for the victims and for the claimants in a particular case, it also has a trickling effect in the societies that are actually affected by the claim, by the scenario, by what happens out of the litigation. So in that sense, when we're talking about not only environmental harm, which is possibly where this has developed the most in practice, we think about, for instance, all the litigation in relation to business and human rights. This is clear that the results of a particular case is not only seen as important to those victims, but actually having a much more public interest, right? So in that sense, strategic litigation in terms of public interest litigation in relation to business and human rights has been very prominent in recent years. Now we see the same in relation to environmental crisis and climate change litigation is also the kind of public interest litigation that is gaining track also via private international law. What I see problematic in this context from a global south perspective is the fact that the channeling of these litigations in the global north at times take away the possibility of dealing with these issues in the place where the actual harm is suffered the most. And this is very clear in the case of African countries, for instance, where victims tend to seek recourse in the global north, and then the measures are not necessarily so influential in changing legal infrastructures and actual having that trickling effect, that social trickling effect back where the harm was originally produced. So I think we need to think more creatively, of course, always with access to justice in mind and facilitating transnational access to justice, but bearing in mind that that tension and that asymmetries and interdependencies between the global south and the global north need to be part of what private international law does. So in the name of access to justice, we shouldn't be working in a way that reinforces those asymmetries and continues to develop legal infrastructures in the global north to the detriment of those developments in the global south. And I think that is a key message of my own scholarship that I wanted to put forward to you all. But I won't take more time. Thanks so much for having me today. I am delighted to be here, and I remain at your disposal. Thank you very much.
Thank you so much, Veronica. Thank you.
Thank you, Veronica ma'am, for telling that private international law can and should serve the public good like sustainable development. Now I will call Annapurna to carry the presentations forward.
I now request all the presenters, both those present here in the auditorium and those joining us online, to kindly take their respective places and be ready to begin with. Firstly, to start with, I now invite Dr. Sridhar and Dr. Boyala Kiran, who are joining us online, to kindly begin their presentation. And their presentation is on the topic Decoding the Enigma of Crypto Insolvencies Beyond the Borders. Thank you.
Good afternoon, everyone. Am I audible?
Yes, sir, you are audible.
Okay. So I'll try to finish it within 3 minutes, and my co-author will continue for the remaining 4 minutes. The time allotted is 7 minutes for us. So the basic fundamental idea of our research paper is cryptocurrency, insolvency and cross-border enforcement, rethinking property, ownership and jurisdiction. So we are looking from the insolvency law point of view, where if you look at the basic ideology of insolvency law is, whenever if any company went into liquidation, we are going to pool all the assets and resolution professional will be appointed. Then he is going to form the liquidation estate. Then we are going to realize the liquidation estate. Then we are going to distribute it. That is the basic agenda or basic fundamental concept behind the insolvency. But when we look at the cryptocurrency, if any company invested in the cryptocurrency, the basic idea of ownership is at question, and custodial rights, that is also in question mark. So suppose if we are investing somewhere else, that is in other jurisdiction, even that is also in question mark. So in this slide, we are having few question marks, the research questions. Can cryptocurrency be effectively characterized as property within the meaning of insolvency law framework? Will it be called as property or not? That is what we are going to question. Then how ownership and custodial arrangements between exchanges and users affect the rights of creditors and investors in insolvency proceedings, how it is going to impact the creditors. Then whether existing mechanism of cross-border insolvency, including unilateral model law, are sufficient to address the challenges posed by the global crypto business. So first 2 points I'm going to concentrate. The next one, third point, is going to concentrate by my co-author, Dr. Kiran. So let us try to understand the legal nature of cryptocurrency and ownership. So whether cryptocurrency is a property or not. If you look at the property definition, property means something underlying asset must be there. Whenever we are looking at the property, some underlying asset must be there. Whether cryptocurrency is having underlying asset, there is a big question mark. We don't have any underlying asset. So that's why I can say that the Indian courts or even the courts in UK as well as Singapore also, they have approached the functional approach. That is nothing but because we have to recognize, there is a necessity is there, though it is not satisfying the basic economic fundamentals, but we have to recognize, compulsorily we have to recognize the cryptocurrency to give some money to the creditor. So that's why the courts has followed the functional approach. So they have given the proprietary character, like in the case of A versus person unknown. The English High Court held that Bitcoin constitute property, as even in the case of B2, C2 case law, the Singapore court identified that cryptocurrency is having the characters of asset. But the question mark is that whether cryptocurrency is having the ownership. Do we have any person who is purchasing the cryptocurrency? Are they having the ownership? Are they having the custody? That is another question mark. Why? Because cryptocurrency, when I'm investing in the cryptocurrency, it is largely or basically governed by the contractual terms between the platform and the investor. So when the platform term says that the platform owner is having the ownership, I don't have any ownership because it is purely depending on the agreement between the investor and the service provider. So whether am I having the custody, fact to say custody is also not practically possible because the platform owner will have the custody over the cryptocurrency. So here I can say that the ownership is in question mark and the custody is also in question mark. So if you look at the economic analysis, the economic angle of the cryptocurrency, whenever if you consider any property, So one of the fundamental character of any property is that, as per the economics, the property must have the intrinsic value. Unless the property is having the intrinsic value, as per the economics, it is not considered to be property. Whether cryptocurrency is having the intrinsic value, no. And other character of any asset under the economics is the asset must have the exchange value also. So exchange value should derive from one underlying asset. Whenever I am saying that exchange value must derive from the underlying asset. But in case of cryptocurrency, we don't have any underlying asset also. But merely here we have to understand that because there is a demand and supply is there. Because of the demand and supply, there is exchange value is there for the cryptocurrency, but that is not the real exchange value according to the economics. So this problem is there. So traditionally, economics, if you look at the economic analysis, we cannot recognize cryptocurrency as a asset. So now, if you look at the 1 minute, let me change. So if you look at the insolvency proceedings, what is the role of insolvency professional? The slide is not changed. Is it changed? You can continue. Yeah, it is changed. So if you look at the role of insolvency, role of resolution professional under the insolvency proceeding, the resolution professional is expected to pool all the assets, and he is expected to form the liquidation estate when they are taking care of the CRP process, or in the case of liquidation process also. Now, the problem is that here, in case of cryptocurrency, whether resolution professional, is he really having capacity to assess these assets? And majority of these cryptocurrency assets they are having the private keys. It may not be practically possible for the resolution professional to get the private keys and form a part of the liquidation estate in case of insolvency proceeding. So that is one of the major problem that we are having. Even if you consider the avoidance of transactions also under the liquidation proceedings, buffet transactions, preferential undervalued transactions, if we are having the cryptocurrency, because this is totally regulated by the private keys, where individual is having the control over the cryptocurrency, if any individual who happens to be promoter, if he transfers without the knowledge of the other board of directors, if he transfers his property to other person, that is cryptocurrency to other person, as undervalued, then whether resolution professional, can he say anything, or can he have any remedy for that? So these are all the various problems that we are having under the CRP process as well as liquidation process. So, Kiran sir. So my colleague will continue with the jurisdictional conflicts.
Thank you so much, sir.
Sir, please try to complete it fastly because we have limited time.
I'll finish in 2 months, nothing more than that. So now that we understood that in spite of all the struggles, we still have to consider crypto as an asset. The issue turns out to be a little more problematic when we bring in various jurisdictions, particularly because crypto doesn't know borders. It is per se, somebody can set up a coin exchange here, and somebody can buy it from different parts of the country. So it can be treated as an asset in one country, it may not insolvency, give us a direction. So drawing from Hegde sir, drawing from Veronica ma'am, we move on to the idea that conceptual provides for access, recognition, relief and cooperation as 4 pillars under the model law, but it can never work unless we bring in coordination. So that's where the soft law protocols that we have, whether it is the protocols that are entered into between the resolution professionals and the state supported entities in that particular insolvency, or the judicial information network, the JIL guidelines that are there, where they try to bring in coordination related ideas in reality so that it can be effectively enforced for the benefit of the state.
Presentation. I now invite Mr. Pothur Gautam to kindly deliver their presentation, and I request the presenter to complete it within 5 to 7 minutes in the interest of time. Thank you.
Good evening, everyone. I am Pothuri Gautam from first year VSL. It would be honor for me to present my paper here. That is, the title of my paper is From Principle to Regulation: The Role of Artificial Intelligence as Evidence in Conflict of Laws. Coming to the main problem, the main research question here I am accounting. The main research question here I would be dealing is, how can AI evidence be safely integrated into conflict of laws framework? Coming to the three numbers, 195, 79 and 0. There are total 195 legally recognized countries in the world. And coming to the percentage 79. AI can predict 79% of the outcomes of the judgments accurately in ECHR, that is European Court of Human Rights. And coming to the number 0, in spite of this, there is no unified law governing AI to produce evidence and generate evidence. Coming to the three main pillars of international law, they are jurisdiction, choice of law, foreign judgments. Jurisdiction is in India is dealt by Section 20 of CPC. Section 20 of CPC describes the jurisdiction can be claimed where the defendant resides and where the cause of action has happened. And coming to the doctrine, foreign non-convenience. The doctrine says the court can decline its jurisdiction. And coming to choice of law, in private international law, where two or more laws collide with each other, which law can be applied to deal with the case? And if we come to property law, contract or torts, there is a doctrine called double actionability rule. It says the act should be legally wrong in both the countries to be treated. And coming to foreign judgments, as private international law has only persuasive effect in the Indian courts, and the Indian courts are not binding on the private international law. It's a big challenge on the enforceability of the private international law. And coming to the challenges coming to the challenges by AI. AI operates borderless. That means an AI can be made in a country, say Singapore, and can be trained in America and used in India. And with this, a problem jurisdiction arises. And coming to AI generated evidence reliability, it's lack authentication. Coming to the next slide, AI as every coin has two sides, AI has also its dark sides. Coming to the pros, it has predicted 70% of US Supreme Court judgments accurately, and it has predicted 79% of the judgments of ECHR accurately. And to implement private international law in the judgments, they should be proven with expert evidence. The expert evidence can be proven by international expert in private international law advocate, and he can use natural language processing model of artificial intelligence to process it. If we coming to other dispute resolution platforms such as eBay use smart settle AI tool to deal with cases more efficiently. The main feature of this tool is it gives judgments based on the thing. It benefits both the parties more efficiently. And coming to the cons of the AI, algorithm bias. AI is mainly trained by historical records and historical data. And because without any human intervention, because of the data, AI can discriminate based on many things. And coming to black box obfuscation, AI, the code that runs behind the AI cannot be accurately determined. The reason behind the judgment cannot be accurately defined. That is the key essential feature of Indian judgments. Why the reason behind the judgment? And coming to privacy violations, AI uses previously data to give output, and that output can be highly influenced by the past data. AI takes input from one person and gives output to another person. This ultimately infringes the privacy of the person. Alignment problem. Sometimes AI's decisions might be in conflict or in conflict with the decisions that are taken by the humans. And coming to section 61 and 63 of BNS, they deal with the admissibility of electronic evidence in the court. And to use AI as evidence, I have created one framework, that is source algorithm output framework. Source is the thing that is used to train AI. And algorithm is the processing behind the screen that AI uses, the process in which AI uses to give an output. Output is the final thing that AI gives. Output is the final thing that AI gives as the judgment after analyzing all the evidence. The main key things in this are relevance, admissibility, and appreciation. The evidence should be, like AI is used to determine these three elements. The evidence should be relevant to the facts of the case, and it should be admissible in the court, and if the court uses it to give the judgment, it is considered as appreciation. And coming to the next slide, I want to conclude my presentation by by telling the main key takeaways of here. Currently, the AI cannot be used to deliver judgments because the current judges and the current judiciary is not at a position to analyze and process the data behind it. And we need a codified private international law to increase the efficiency of the system. And I want to end it by a quote. Building AI for efficiency and speedy delivery of justice, but to guarantee that the scales of justice remain balanced across cross borders. This means AI can use to increase the efficiency, but it should be done without any personal bias and discrimination. Thank you.
Thank you for the presentation. With that, we come to the end of presentations. I now invite Pranav sir to kindly take over the stage.
I would like to invite Dean sir and Anandu sir, assistant dean, for the felicitation. Thank you, sir and ma'am, for your presence and time. Sir, what is Now we'll have a tea break after this. Thank you, everyone.
Accomplished personalities with us today. I now extend a warm invitation to our distinguished guests, Dr. Manimuthu Gandhi sir and Dr. Rajalakshmi ma'am, to kindly come forward and share your insights with us. I also invite the moderator for this session, Dr. Angel Shaji ma'am, to join us on the stage and guide this session. I request Angel ma'am to take the session forward.
Good afternoon, everyone. It is a great honor and privilege to welcome you all to the two-day international conference on private international law in the era of new emerging technologies, issues, challenges, and the way forward. Organized by the VIT-AP Law School in collaboration with the Indian Society of International Law. We are especially grateful to our esteemed guests whose expertise and insights will guide us through these important discussions. To all the participants, I encourage you to actively engage, share your perspectives, and make the most of this opportunity. Conferences like these are not just about listening, but about learning, questioning, and collaborating. On behalf of the organizing committee, I extend a heartfelt welcome to each one of you. I would like to introduce our esteemed guests. It is my privilege to introduce Professor Dr. M. Gandhi, sir, a distinguished scholar, practitioner, and diplomat in the field of international law. Professor Gandhi currently serves as one of the Vice President of Indian Society of International Law and is an independent legal consultant in international law. He previously served as a professor and dean at VIT School of Law, Chennai, and also as professor and executive director at the Center for International Legal Studies, OP Jindal Global University, Sonipat. He is an accomplished teacher and practitioner of international law. He served as a member of the legal team in the Ariel incident case 1999, decided by the ICJ in India's favor. He has also served as a legal advisor at the Permanent Mission of India, New York, representing India in the 6th Legal Committee of the UNGA. He has participated in a number of international conferences, negotiating international treaties and agreements, and also working groups on international law, representing the Government of India. He received specialized training in legal advice and legislative drafting from the Institute of Advanced Legal Studies, University of London, under the Colombo Plan, and was also a visiting scholar at Columbia University through UNIDA. An accomplished teacher, researcher, and practitioner, Professor Dr. M. Gandhi has authorized several research articles and book chapters in international law, published both in India and abroad. I warmly welcome Professor Dr. M. Gandhi, sir, to the stage.
Good afternoon to all. It's a great privilege to be here among scholars of private international law and students of private international law. The whole morning session, we have great speakers and professors speaking on private international law. And those who are all practicing that area also spoke with you. And Dr. Rudal Rangreji, forensically, he approached private international law. And Dr. Hegde, he has taken you the entire breadth of international law, how it looks. But the depth of international law was Hegde. He said almost in the operative areas of private international law, how it works. Now I am concerning myself with law of the sea and conflict of laws with special reference to shipping contracts, collision and liability. This appears to be a new area, but it is not new area, it is an existing area. But they very much not concentrating that the private international law issues are involved in that. See, the private international law is not international law. Many people would say that, it is international law. Private international law is a municipal law, where when the conflicts of law comes into play, the dispute is settled, how it is resolved, and what are all the principles that resolve them. Only those things are given. You give a shade of private international law because multiple legal system and principles are involved in deciding a dispute. So what is important is, from forensic level, it is the dispute settlement. And the dispute settlement, you have to identify the law, you have to identify the forum, you have to identify the procedure, you have to identify if a degree is made the recognition, if it is a recognition is that, how it is informed, where it is enforced. So these things are there very much. But the issue is, if one forum you got a degree, and where you will be really able to just enforce it. This is really a problem. And the web of public international law, that helps you to do that. Say, for example, the law of the sea, where, the maritime law we call this, it is a specialized area of law that deals with many complex aspects to do with use of the sea, including relevant legal rules and regulations that are based on contract law, tort law, law of agency, law of insurance, arbitration, and dispute resolution. All these things will come in a set in one decision or another decision when it is called for. It forms part of private international law, which governs arrangements and relationship between private individuals and entities who are owning, controlling, operating, and using sea-going vessels. But how it has been done, if you just look the history of it, you can see that the sea contracts for carriage of goods by sea, we traditionally use this, and this is in vogue from 15th century, not now. So it is a 15th century municipal practice of European states. And all of them are, then they codified it, and this codification gave rise to the collection of such usages in 13th centuries and till mid-5th century, 15th century. So the practical international carriage of goods by sea have been made their way internationally binding rules of law. The consequently, upon newly privately led process, codification by originally International Law Association and later Comte Maritime International. And that paved way for uniform rules of substantive nature governing carriage of goods by sea, of which the Hague Rules of 1924 is, everybody knows that that is a basic rule. Now, there are other rules too. In the 60s and 70s, rules are laid down by intergovernmental organizations. Hamburg Rules of 78, Rotterdam Rules of 2009. The Rotterdam Rule is, a very special mention. I want to make it that what we are now talking about, that, this the electronic, ship lading and other things, Rotterdam Rule is dealing with that. But unfortunately, not many takers of Rotterdam rules. So all the regional level, now regional level, this was referred again by Hegde. He was telling about Rome I regulation of number 593, 2008. See, the problem here is, even the conflict of laws itself, there is a conflict. Because one side you are talking about unification of the rules. And people mention that it is a Eurocentric rules and other things. The other way, you say that party autonomy. So when a party autonomy is there, and whatever the rules that you have developed, that need not be accepted by party. They may go for even combined rules. So that is a problem. In one such case, very latest case, where the UK Apex Court rejected the very idea of, the European Rome I regulation, when it is contradicts with the proper law of contract identified by the court. They said that we will even reject the Rome I regulation. So the regional conflict of law rules and the choice of law rules, when there is a conflict and the courts are taking a decision in such a certain way, this has happened after pre-exit. Because, when they exited from European Union, they no longer wanted to have it. Therefore, they said that, we will not go by that. So normally, we use I think the Hague-Visby rules in the sense that as much as entrenched in our shipping law, not the freestanding, Hague-Visby rules. So we play by rules in the sense that all the private international rules. Why they say private international law, I told you that. These are all municipal rules, and general practice are collected. When the collected rules are stated there, and the states are willing to accept that, therefore it becomes private international law rules. And these rules find a place in the statutes of different countries. Now, so this is applicable for these rules for all the shipping contracts. There are about 18, 19 type of contracts, charter party, and all these things you can find. The whole of the rules applicable, as well as you have jurisprudence developed in each municipal jurisdiction. So if you want a favorable decision, sometimes, you have to shift the forum. They say that, forum, the selection of forum and forum shopping, that also would happen. And these things are planned very well even before the contract is drafted. So when the contract is drafted, they will identify the proper law to be applied. So they say that choice of law. When they say the choice of law, and it was very interestingly explained in a clear way by Hegde that, when a contract, you have a law, that particular law you identified in the contract, and that will be unambiguous, that will be applied. If there is an ambiguity, you are leaving to the court. When if you are leaving to the court, he said that the nexus with that party, that must have a link to that. Therefore, jurisdiction is based on that. So in the forensic level, it is complicated as far as one part of it. Once the claim is, it's all right, they accept, they award it, then comes, so the recognition comes first, and after the claim comes in, the reward comes in, then, whether that can always be, in fact, enforceable or not. For that, you have to select for the forum also. When the selection of the forum, then international conventions will help, like New York Convention. and you may have some European convention or instrument that will facilitate that kind of enforcement. So interesting part is that these principles evolved internationally, and it is internationally evolved principles where it is not the government is involved in that. It is the private parties and the associations and intergovernmental organizations are involved in that. So they, whatever the rules they produced it, and that will be applicable. Therefore, to make it, possible, and most of the countries will select that particular, the set of countries, they adhere to the rules of the particular regime. So it is easier for us to do that. Now, the rules of domestic law, either the law chosen by parties or the law applicable in the absence of choice, will anyway deemed to apply in respect of contract. That's what he explained, the G.G. Hegde. Now, the ship collusion, and the enormous number of ship collusion that is happening everywhere. Generally, ship collisions can be catastrophic with major damage to the ships involved. The loss of lives and considerable marine pollution with the disastrous consequences to the marine ecosystem. The following examples highlight several lessons of the failure to the company comply with the cold drug regulation. The cold drug regulation is, again, the cold drug regulation is international regulation. That is, the failure of navigational safety and watchkeeping practice, absence of a proper lookout, insufficient training, and bad weather conditions. Now, here is a turn, in the sense that if you are using the AI for that, now, whether it is due to the negligence, whether it is due to the machine, the failure, whether it is due to the other reasons, weather or other reasons, they can easily be produce evidence today. It was not possible earlier, because you have to go for circumstantial evidences. Then they may have all parties involved, the states which are involved in one way or other, whether it is the ship is owned by one state, registered in another state, and party is at another state, and all the joint investigation is done, and to bring in the evidence before the court like that. Now it becomes easier if you are using the AI. Still, the problem today is that when we are using the automated ships, because due to the developed science and technology today, and the ships are automated. When if it is automated, the negligence on whose part? So your standard of duty that is cast upon a particular party, that can easily be, now it can easily be questioned, because the person is not there. It is a personal ship, and nobody is there to captain the ship, but the ship is moving. So these problems will come today. Now, there are quite a number, even the 24, the ship collusion, it is, there are long list of cases. If you see that the collusion list in the, the directory by internet, you can find that, and which are all the tankers which are all there, and how that collided, which are all the parties, they belong to which country, as far as the owner of the country is whom, and the register of the ship, which country, all these things you can find that. Right. Then, and another important reason is that fixing that, which jurisdiction you have to see, you cannot decide without the help of public international law. Also, private international law is the municipal set of rules you apply. But the jurisdiction, as far as the law of the sea is concerned, only three kinds of jurisdiction you can find. One is the port state jurisdiction, the second is coastal state jurisdiction, the third is the flag state jurisdiction. If these three jurisdictions are there, and one of the jurisdictions where the country is there, you will be able to just approach that country. Otherwise, you have, if it is a collusion and other thing, there is no kind, not even a single piece of paper that will be available to choose your, the forum at the particular point of time. So for jurisdictional purposes, first you have to cross the jurisdiction which are all governed under the law of the sea. Then only you will be able to do that. And finally, another thing, I want to just, refer to. This is in connection with the sustainable development issues that there was one speaker. Then she was talking about that, how it helps. Now, what is happening is that in British courts today, by and large, we are using the British system of private international law, almost all common law countries. But that is not the only system, I'll tell you. Because in USA, still they won't call this as a private international law. They say it is only the conflict of laws. They won't call this as, the private international law. But most of the Commonwealth countries, especially in Asia, you can find that most of them are governed by the British private international law, and those rules are in fact applied with mutatis mutandis by our courts here. So one other thing very interesting is that especially in identifying the corporate responsibility in matters of duty to care in case of tort-related issues. In Vedanta case, where, this UK court, because there was a petitioner from Africa, he approaches UK court, he says that, the company is responsible for all kinds of pollution and other things. Therefore, it is a private international law case because it is a tort and that affected many people there, and court said that despite the fact that the African subsidiary of Vedanta has done all these things, they made a fundamental rule now that all the subsidiary is liability, especially with regard to the tortious liability, and it is the main company and is responsible. In 2-3 cases, they lay down. Why I am underscoring that, it has its own connection with sustainable development idea that, it should be linked. I can stop here. You may ask any questions at the time of question and answer session. I'll be able to answer you. Thank you.
Good afternoon, everyone. It is an honor to introduce our distinguished guest, Professor Dr. Rajalakshmi B. Madam, Honorary Faculty at Dr. V.R. Ambedkar College of Law, Andhra University. With over 3 decades of experience in legal academia, she has established herself as a respected scholar in public international law, environmental law, and socio-legal studies. She holds her LLM and PhD from Andhra University and has made valuable academic contributions through numerous books, book chapters, and research publications. Her academic excellence has been recognized with honors such as the Best Research Award from Andhra University and the Peri Narayana Shastri Gold Medal for Best Thesis. She is also a life member of Indian Society of International Law, Indian Law Institute, and Indian Institute of Public Administration. We are privileged to have ma'am here for this technical session, and I warmly welcome Professor Dr. Rajalakshmi Madam to the stage.
Good afternoon, everybody. Friends, today we have assembled here to look into a very important aspect concerned with 2 things. One is to do with biotechnology, and the other one is to do with private international law. Well, as you know, the basic theme of this particular conference is emerging technologies and their implications to private international law. Well, the importance of this topic lies in the fact that currently we are living in a society which is highly techno-driven. In fact, somebody said that in human world, technology has become a bosom companion, where perhaps it is very difficult to extricate technology from the human life. It's not as if it's a modern, this kind of a companionship has a modern origin. I would say that since very long time, even from the days of jungle life, technology has been a companion. But the difference that comes in the technology of earlier days and the current times is, in the earlier days, technology was like, no doubt it's a friend, it's a good companion. It was a kind of a friend which would be supporting us when a human being unable to do something, where technology is a result of human ingenuity. It is like, it is pulling the human being out of that particular risk, and it's like a friend, somebody when you are in a trouble, it will give the necessary help and then give us a sense of assurance that here I am, you can go ahead, I am there to support you. But the technology of this kind is, it has become highly invasive, it's almost like it is giving you the direction as in which way the humans would have to lead their life. It has become, in many times, it is like always, right now we are in a world where it's always comforting to have somebody who is a reassuring kind of a friend, but to have a very pushing kind of a friend, imposing kind of a friend, dealing with that friend is very tough task. So that is the state of affairs so far as our human life in the techno-driven society is there. Now, I feel technology of late, all modern technologies, there are such mind-boggling issues surrounding the use of these technologies. In the morning, I heard some presentations, one on artificial technology, one on space technology. So this is something like there are mind-boggling issues. And on the other hand, private international is something which I feel is something like where the nature of private international is that there is no definite framework as such, because obviously it is something to do with individual countries, what their law is, what principle of private international they have to apply for a state, for a given state of affairs. Private international is always considered to be something which is challenging one. So technology is dealing with, looking into technology and understanding their ramification, that is one challenging task, and then trying to examine technology within the framework of private international is another daunting task. But anyway, it is necessary for us to involve in this exercise because many times we find ourselves at crossroads as to what should be the direction. So friends, my focus is on biotechnology, one of the emerging technologies, a technology which has come it has taken up like anything. And this is one of the technology, amongst all the technology, I would say that biotechnology is a very invasive kind of a technology where many apprehensions surround the use of biotechnological applications, as whether it is appropriate for us to use the biotechnology, because there are many risks which are supposedly associated with biotechnology. Why it has come a big way is because there are equally so many advantages out of it. So naturally, whenever there is something which is very advantageous, obviously there will be a lot of importance would be given to that. Trade automatically would come to be associated with that. Once it attracts the potential of the trade, obviously dealing with the link between commercial character of the technology and the necessity to regulate that becomes a difficult task. But anyway, our focus is about private international law. Let me just give you some of the advantages of because I found most of the listeners are youngsters. So I think I'm going little into the basics of it. I maybe excuse the experts over here, might excuse me here. Friends, when it comes to biotechnology, there are so many advantages associated with that, like that is being widely employed in agriculture, in health field, in medical field, reproduction field, and many industries are employing that. For example, if you take the case of agriculture, if you use this biotechnology, all the advantages like you can have a higher yield and you can enhance the nutritional levels and you can have such organisms which would be naturally resistant to pests or insects. And the promise that is made is because when the creature or when that particular organism is naturally resistant to something, you do not have to use any pesticides or insecticides. So thereby we can stop using highly environmental harming pesticides or insecticides. So all those things can be eliminated. So these are like you can enhance the nutritional values, sometimes aesthetic appeal, etc., etc. So therefore, it seems to be it is very attractive as such. But at the same time, we have to understand that nowadays genetic engineering has come up in a big way when we say that it's something to do with manipulation of genes. There are various technologies. I am not going into that gene repressive, gene enhancing, all those things. But the point is that gene is the ultimate unit of, say for example, any living creature. If this is manipulated, well, it might yield positive results. Apparently, it might give a positive result. But over a period of time, whether it is going to be beneficial to human survival or if any living organism or whatsoever, or maybe it would lead to some other negative consequence which we might not have foreseen at this point of time. So if at that point of time, whether we would be able to reverse the damage. Suppose if the damage is irreversible damage, what can be done? So taking these apprehensions into account, certain responses have come from public international point of view. While you might be wondering that our discussion has to be on private international, why is it that I'm talking about public international? Because I'm trying to draw a link between public international and private international, and ultimately my recommendation is that whatever academic deliberations that we may be undertaking, it's very important that we have to create, there is an acute need to develop synergies between public international relating to biotechnology and also private international implications of biotechnology. This is my major submission. So therefore, just for that sake, once again, because of the students, let me give you some of the initiatives that had come from public international. See, biotechnology is something which employs a biological material or a biological process to bring out a new thing, to come out with a new product. Basically, it is to do with life system. So once the moment you take into, you are utilizing any life system, it has implication to environment. So therefore, taking this into account, not just purely because of the biotechnology, but otherwise also, international community had taken the fact that there's a lot of destruction of biological resources and they need to be conserved and they have to be sustainably used. We cannot have such an ideal goal that we have to conserve the biological resources and nothing else, because we also have to survive, because we also have to develop, and biological utilization of the biological resources is a major means of economic prospects. Sustainable development requires that you have to balance the goal of conservation and also the
prospects of economic development in a balanced manner. So with that idea, international community has adopted a convention by the name Convention on Biological Diversity. In that, it came out with a novel concept known as benefit sharing. My focus is going to be on that aspect. That's the reason why I am giving you these details. As per this, the convention requires biological resources need to be sustainably utilized. That is one thing. They have to be conserved. At the same time, they can be sustainably utilized. And benefit sharing is a concept where when the resources are being used, that is what is done in the biotechnology. It is with the help of biological resources or biological resources that you are developing biotechnology. So if biotechnology goes in a bigger way, automatically the impact is going to be upon the environmental base, that is biodiversity. So therefore, the concept is where biological resources are taken from any country, the benefits that come out of the utilization of these resources, suppose out of a biological material, a product could be innovated, the benefits arising out of the technology, those benefits must be shared with that country from which that particular biological resource has been extracted. That is the idea. Now, this is which is specified by the Convention on Biodiversity, and subsequent to that, another protocol has been added which expanded the idea of benefit sharing mechanism. So wherein it said that countries, state parties, they must have some mechanism to have this, to facilitate this benefit sharing mechanism. And then there are these recommendations like countries which are providing, they can have agreements with reference to that resources. While these resources are being shared, without their consent, other countries they cannot extract, or anybody can extract the biological resources. So therefore, MAT means material transfer agreements, with conclusion of these agreements, which shows that there is a consent from the country from which the resources are extracted, benefit sharing arrangements could be made. So a detailed mechanism has been laid down under ABS protocol. This is a basic introduction that I want to give in this regard. Friends, as a country belonging to South, belonging to third world countries, belonging to South, it's important for us to know that India is one of the rich countries in terms of its biological resources. I think it stands its sixth position in the position of this rich biological resources, and therefore we have a lot of interest in the conservation of these resources and also sustainable utilization of these resources. And in the process of it, we have lot of stakes in this concept known as benefit sharing. So when we are rich in these resources, obviously, maybe companies or maybe other countries, like there will be, we can provide access to others to develop technology, and whatever technology, whatever benefits that arise out of that technology, we would be receiving these benefits. Now, in this context, there will be implications from the international, private international point of view. See, where there is an agreement, there is an agreement, like any other foreign contract, where there's a contract concluded with a person or a company, private entity of another country, we come across variety of implications, like suppose there is a breach of contract, questions would be arising as to which country should be dealing with that matter, questions of jurisdiction. The next question would be what law, by what law the matter has to be decided, what is the appropriate law to be applied, and then in case any judgment already has been given in a foreign country, whether the judgment can be enforced in our country or not. All matters relating to private international law, they essentially revolve around these three features. One is, there could be questions about whether a country could exercise its jurisdiction or not, a court of a country can exercise its jurisdiction or not. Second one is, when it exercises its jurisdiction, by which law the matter has to be decided, what is the appropriate law, is it our local law or is it the foreign law which has to be applied? And obviously, if there is any foreign judgment, whether that can be enforced or not. Now, with reference to a jurisdictional aspect, my appeal is, it is time for India that we should be evolving a principle of international law which obviously would be beneficial to India. And this principle also would be beneficial to entire third world countries. I would explain how. First of all, what kind of a conflicts? I'll just give you some examples. Suppose there could be, as I said that, suppose a foreign company has entered into an agreement with us for supply of biological resources. So, some payment has to be made. Suppose there is no payment made, then obviously there is breach of that contractual term. But then question is, which country has to assume? Is it the country which has provided the biological resources, which is the subject matter of that particular contract, or whether the matter has to be taken up by a country which has taken the material from a country, but it is the one which is using that resource. So which of these two countries must be exercising its jurisdiction? One such questions can arise. And because it's a question of technology, number of questions relating to intellectual property rights also would arise. Many questions would be there. Like, say for example, it has to be patentable. To get patent, it has to be, the subject matter has to be patentable. There are certain questions like, what about genetic information which is stored in digital medium which can be easily accessed? That information is derived from a genetic material. Now the question is that already that genetic material is there. This information is only gathered from the existing material. So can you consider that to be an invention, or would it amount only to a discovery? Some countries might consider this to be a discovery and therefore they might take a stand. No, patent cannot be granted. Or some other countries might consider that even though it is part of this existing one, you have that by your innovation, you are able to discover it. Behind that discovery, there is some innovation. So therefore, it is patentable. So conflicts can arise how you look at the patent, how you look at the patentability of the subject matter to be patented. And question is, and when it comes to use of this biotechnology, there are many safety concerns. In case of any safety issue had come, say for example, if a genetically engineered crop has been implanted here, as a result of which our environment got contaminated or some environmental damage did take place. In such a case, there is some damage. So in such a case, or maybe if you have consumed those genetically engineered food where human health has damaged, there again question is, who should be liable? So with reference to that, whether is it somebody, because there will, when it comes to biotechnology, it would be subjected to multiple legal systems. Variety, somebody might take the material from here and thereafter another country also might come in collaboration. So which of the legal systems, whether all the jurisdictions of the collaborative arrangements, all of them would have basis of jurisdiction, but who should be having the real exercise of jurisdiction? So these are all questions of practical importance. And so these are some of the variety of ways in which various issues would arise from this biotechnology issues. In this regard, my appeal is, I think India should stick to the approach which is similar to an approach which is adopted by our courts with reference to matrimonial matters. See, in the case of matrimonial matters, Supreme Court has settled down to the position that marriage has to be in whatever legal system the marriage has been performed, lex locis celebrationis, where the marriage has been celebrated, that legal system should be applicable for all the aspects relating to marriage. Lex locis throughout, whatever it might be, whatever issues that arise out of it, lex locis celebrationis will be that principle that has to be applied for any issue whatsoever connected with marriage. So my approach is similar to that. We should also evolve a principle, something like lex loci extractus or something like that, where the country from which a genetic material has been extracted, that must be the governing law. Choice of law must only be the law from which biological resource is extracted. So that should be a settled position so that there will not be any, so at least so far as India is concerned, we can create certainty with reference to any issues concerned with biotechnology. So if the genetic material is extracted or a biological resource is extracted from India, it's only by applying Indian law only the matter has to be decided. Whether it is something like to do with breach of a contract or anything to do with intellectual property rights, whatever it is only the Indian law should be the law that has to be applied with reference to entire chain of it, because with reference to genetic technology, plenty of chains could be there, users could be plenty. So therefore, to avoid all that confusion, I feel that we have to settle down with the position that only the law of that country from which biological resource is extracted, we have to decide the issues in accordance with that. Suppose the other country, it might be an Indian legal, it might be in India from which the resource is extracted, or it might be another country from which it might is extracted, and the issue has been subject to the consideration of India. Still, we have to go only by this approach. I think this is one way where you can bring some kind of certainty. And why I say is, this is an approach which will bring synergy between public international and private international. This is where we have to understand the spirit of public international law when it deals with issues connected with environment. So this is something where the international environmental law has progressed in such a way that it is, when it comes to biodiversity, it has given lot of importance to the way it has developed the benefit sharing mechanism, etc. Everything keeping in mind the provider country, interests of the providing country. So therefore, by following this principle as a principle of private international law, I feel we would be in a position to bring a connection between public international and private international, because at the end of it we have to realize private international has got a very narrow focus, public international has got a general focus because it takes into consideration general concerns of the international community. Private international law is something which is connected only with individual disputes. So therefore, it has to be, that spirit of public international has to be accommodated in the private international law application with reference to biotechnology is my line of argument. So this is what my appeal to the scholars of international community are. It is time that we have to develop a deliberate or what to say, an engineered consensus to the acceptance of this principle, which would be in consonance with the spirit of international environmental law, and in the process we would be serving the cause of the cause of protection of biodiversity. So this is my simple submission. And any other questions, maybe I would take it from the students or any academicians from that.
Thank you so much, ma'am, for sharing your valuable insights with us. That was truly inspiring. Moving to the next segment of our session, I invite Ms. M. Manasa Bhavani and Mr. C.H. Praveen Kumar Gupta for their paper presentation. They are going to present on the topic, Jurisdictional Chaos in Cross-Border Data Flows, a Private International Law Perspective on International Minimum Standards. I kindly request the presenters to wind up quickly.
It's not functioning.
Warm greetings, everyone. Today, I'm going to present the paper titled Jurisdictional Chaos and Cross-Border Data Flows, a Private International Perspective on International Minimum Standards. In a world where data travels faster than thought, crossing borders unseen yet deeply fought, the law still walks careful and slow while digital rivers endlessly flow. Today, with a single click, personal data can move across continents in seconds. Yet, the laws that regulate this data remains fragmented, territorial, and often conflicting. This brings me to the central question of my presentation. Can fragmented national data protection laws effectively regulate cross-border data flows? My answer is that they cannot. And I present that the solution lies in the private international law-oriented framework based on international minimum standards. Starting with the definition of personal data. Under the General Data Protection Regulation 2016, Article 4, Clause 1, personal data includes any information relating to an identifiable person. Recital 30 further expands this to include Internet Protocol, addresses, and online identifiers. In India, Section 2, Clause T of the Digital Personal Data Protection Act 2023. Personal data is defined broadly as any data about an individual who is identifiable. However, it does not clearly address indirect identifiers, example only with the PIN code or GPS or the IP addresses. In the United States, under the California Customer Privacy Act 2018, personal information includes browsing history, geological data, and Internet Protocol addresses. The problem is clear. There is no uniform definition. This leads to regulatory inconsistencies across jurisdictions. Second, the issue of data transfer. Under Articles 44 to 50 of the General Data Protection Regulation, regulate cross-border transfers. The law does not define what a transfer actually is. This ambiguity creates serious compliance uncertainty. This raises an important question. Does mere remote access from another country amount to a transfer? However, this question is not answered and not clear because the definition of transfer is being skipped. And before I move forward in my presentation, at this stage, it is important to briefly explain why I have chosen to compare these specific legal systems. First, the European Union, through the General Data Protection Regulation, represents a right-based model where data protection is treated as a fundamental right. Second, the United States, particularly through the California Customary Principles Act, reflects a market-oriented and sectoral approach. Third, the Asia-Pacific framework, along with the countries like China, represents an accountability and state control model. And India represents a hybrid and emerging model combining elements of all these systems. Therefore, this comparison helps illustrate not just differences in laws, but deeper structural divergence in regulatory philosophy, enforcement, and global interoperability. Next, coming to the extraterritoriality and regulatory models. The European Union treats data protection as a fundamental right. This is recognized under Article 8 of the Charter of Fundamental Rights of the European Union. This approach is strict, right-based, and enforced through principles such as lawfulness, fairness, and accountability. In contrast, the Asia-Pacific Economic Cooperation Privacy Framework follows a more flexible and market-oriented approach. This focuses on accountability and facilitates cross-border data flows through mechanisms like the cross-border privacy rule system. Coming to the role of cross-border data transfer rules, cross-border data transfer rules across most legal systems do not act as a main regulatory tool. Instead, they function more like safety values. Example, OECD guidelines of 1980, revised in 2013, state that countries should avoid unnecessary restrictions on cross-border data flows while still ensuring adequate protection of personal data. Similarly, the United Nations guidelines of 1990 allows cross-border transfer where proper safeguards exist, but also permits restrictions when necessary to protect privacy and national interest. So here the idea is that data should flow, but with protection. Coming to the regional instruments and their evolution, building on these principles, regional frameworks develop more structured approach. First comes the Convention 108 of the Council of Europe on 28 January 1981, introduced one of the earliest harmonized system. Under Article 12, data transfer are allowed only when the receiving country provides a similar level of protection. This directly influenced the European Union system. Under Article 45 of the General Data Protection Regulation, transfers are allowed only to countries that ensure an adequate level of protection. This is called whitelist approach. In the contrast, the Asia-Pacific Economic Cooperation Privacy Framework follows a different model. Here, the responsibility remains with the data controller. Even after transferring data, the organization must ensure compliance. This is implemented through the cross-border privacy rule system. So, unlike the European model, this approach is more flexible and decentralized. Coming to the India's approach, India adopts a hybrid approach. Under Section 3 Clause C of the Digital Personal Data Protection Act, the law applies even to processing outside India if it relates to offering goods or services within India. This is similar to the European Union's extraterritorial approach. At the same time, India allows cross-border transfers by default except to restricted countries, showing a more flexible stance. Therefore, India combines elements of both strict regulation and practical flexibility. Now, coming to the private international law challenges, this brings us to challenges under the private international law. First, conflict of laws. In the digital space, multiple laws can apply simultaneously. There is no clear territorial connecting factor. This creates legal uncertainty. Second, compliance cost. Businesses must comply with multiple overlapping regulations. For example, European law requires impact assessment and strict accountability. India allows transfers but imposes sector-specific restrictions. Complying with all these frameworks together is costly and ineffective. And the third issue is the forum shopping. Companies may route data through jurisdictions with weaker regulations. This undermines global data protection standards. And fourth one is the enforcement gap. There is no global enforcement mechanism. Even if a penalty is imposed in one country, there is no guarantee it will be enforced in the another, because data is fragmented and data do not have proper origin and difficult to find. And mutual legal assistance frameworks provide cooperation but not effective enforcement. Limitations of existing solutions. Existing solutions are very limiting in nature. Coming to the trade agreements, example GATT allows regulation but restrict trade barriers, creating tension between privacy and economic interest. Especially Article 14 of GATT says that trade can be, data protection can be imposed, but however, it shouldn't have the adverse effect on trade. And then soft law instruments, such as the Organization for Economic Cooperation and Development Privacy Guidelines and the United Nations Guidelines for the Regulation of Computerized Personal Data Files, are non-binding and are weak in enforcement. Coming to the contractual tools, like standard contractual clauses and binding corporate rules, are complex, expensive, and impractical for small businesses. Data localization, as seen in many countries, partially in India, creates isolated data systems and reduces efficiencies in global trade. My recommendations are that international minimum standards should be introduced in private international law as well. Because instead of full legal harmonization, I propose a more practical solution. There are not uniform laws, but baseline obligations that all countries can adopt. Because data can be originated anywhere and transferred anywhere in split seconds. First, substantive standards such as lawful processing, consent, and rights like access, correction. Second, a risk-based transfer framework that focuses on the level of risk rather than geographical location. Third, institutional cooperation between data protection authorities, including joint investigations and mutual recognition. Fourth, technological safeguards such as encryption and privacy enhancement technologies. Fifth, integration with the international trade framework to ensure both data protection and economic efficiency. Okay, I would like to conclude saying that data governance today is fragmented, overlapping, and inefficient. National laws are strong individually, but they do not work well together. Private international law struggles with jurisdictions, applicable laws, and enforcement. Therefore, the solution lies not in rich unification, but in flexible international minimum standards. Thank you.
I now invite the next presenter, Ms. Sanjana Jalipalli. The title of her paper is Prenuptial Agreements Across Borders, Issues of Recognition and Enforcement in India.
Good evening, everyone. I'm Sanjana Jalipalli, a third year BBA LLB student. Today, I'll be presenting my paper titled Prenuptial Agreements Across Borders, Issues of Recognition and Enforcement in India. So when we talk about today's theme, increasing digital connectivity, so my study focuses on the implied effect of emerging technology, which is global mobility. So when there is global mobility, which will lead to more cross-border relationships, making issues like prenuptial agreements and conflict of laws even more relevant in today's interconnected world. So association between two individuals does not just bring them together, but also involve in the consolidation of their rights, responsibility, and statuses, which also involve in digital assets. The result of their combination depends upon significant traits they carry with themselves for survival. The legal status of prenup remains conspicuously undetermined within private international law discourse. When such an undecided space is needed to be solved, it investigates the aspects of domiciliate and similar entities. And also with rapid migration, creates the space to reflect upon this. As the ultimate legality for legacy creation depends on the certainty of rights, duties to be performed by an individual in the respective subject, which is now following into every other aspect of private international law. And the theme becomes central when it questions the stance of law and its legality, determining which law would come into rescue when there can be interference of customs, as well depending on its reliability on personal law. This topic becomes important in today's globalized world, when marriages are no longer confined within one legal system. When people move across borders, their relationships bring complex legal questions with them. At the heart of this paper is the fundamental conflict. At one side, Western legal systems treat marriage as a contract, where individuals have the freedom to decide financial arrangements. On the other side, Indian law traditionally views marriage as a sacrament, which cannot be reduced to a private arrangement. This ideological clash makes it difficult for Indian courts to accept these agreements, especially when international elements are involved. This problem only gets more acute when it comes to international relations, in particular, what should happen to such agreements when signed abroad by Indians of different categories. Will it still have any bearing on the proceedings in Indian courts, where both spouses will presumably find themselves? And how does private international law treat it? And what happens to a prenup when it crosses borders and comes to Indian courts? While such a distinction may seem abstract, it has embedded implications. As more and more jurisdictions adopt an approach to viewing a marriage as more contractual manner, largely increased to certainty. Indeed, prenup are often considered signs of either pessimistic thinking about a union or even encouragement for its collapse. This paper studies how Indian courts deal with foreign prenuptial agreements. Using private international law, and also such agreements, but should at least recognize them as an evidence to move towards a more balanced approach that protects both autonomy and social justice. Moving from the traditional view towards a modern contractual view, later with the incidence of foreign approach, this raises an important question: is the resistance truly legal or is it cultural? When such a foreign elements get involved, private international law comes into play, looking at all of connecting factors. And public policy is the most powerful tool that has to be looked into. Whereas the classification of such agreement is a point of contention, as there is at least the possibility of enforcement if it's treated as a contract, and becomes subject to particular laws that are far less flexible if it is seen as part of family law. So, India needs a clear conflict of law framework for dealing with such agreements to avoid any global mobility that comes with the emergence of technology, and should gradually shift towards the conditional acceptance based on fairness, consent, and protection of vulnerable parties. To conclude, this solution lies in a balanced approach, one that respects individual autonomy while ensuring fairness and social welfare. In that sense, law is slowly evolving from resistance towards selective recognition. Ultimately, the challenge is not just about enforcing agreements, but about redefining how Indian law understands such arrangement in an increasingly globalized world. with emergence of digital connectivity and global mobility. Thank you.
Now I invite the next presenter, Ms. Srija Parmi. The title of her paper is Government Access to Data, a New Challenge to Private International Law.
Good evening, everyone. I am Srija Parmi, and my paper title is Government Access to Data, New Challenges to Private International Law. And today I am going to address a legal crisis at the heart of the digital age, the total collapse of territorial jurisdiction. We will explore how the government demands for data from United States Cloud Act to European Union GDPR have created an unresolvable conflict that leaves private international law structurally broken and leaves multinational corporations trapped in the middle. I will start by the core problem, the obsolescence of geography, then with irreconcilable legislative commands, the judicial intervention in the cases of Commission versus Facebook Ireland and Maximilian Schrems, and the impossible corporate burden that follows, and finally a path forward. Let's begin with the collapse of very foundation of private international law is built on, and it's a world of ships, paper contracts, and even the personal laws. But data defies one of those assumptions. We now face a state of fragmented location. A single email doesn't live in one country. It simultaneously resides on servers of various jurisdictions. There is no singular location for a court to anchor the jurisdiction here. And this leads to a fictitious location. Encryption and modern cloud architecture render the physical server location on a legal fiction and not a meaningful jurisdictional anchor. Where the data sits physically is often irrelevant to who accesses it. And this brings to us a real shift, extraterritorial control, and states have realized this. They no longer just assert jurisdiction based on where the data is. They assert it based on the corporate control, who has data in their possession, custody, or control. This is a fundamental shift that private international law has absolutely no tools to dissolve. And the core crisis, this leads directly to my research problem. The fundamental tension is a categorical mismatch. Private international law is built to govern horizontal disputes, but government access to data is a vertical exercise of US imperia, a sovereign act of state power. When United States court issues a warrant for users' data under Cloud Act, and the act conflicts with the GDPR of EU, this is not a dispute between company A or company B. This raises the conflict between sovereign states of United States and as well as the European Union. And next, that legislative collision between the Cloud Act and GDPR. The United States Cloud Act jurisdiction is based purely on provider control. Any data in possession, custody, or control of a US entity. This mechanism is a direct warrant, a command from a US court to a corporation. The only defense is a committee-based challenge, which is discretionary, diplomatic, and deeply uncertain for a company facing a court order. On the other hand, European Union General Data Protection Regulation, its jurisdiction is grounded firmly in territoriality and fundamental rights, protected under Article 7 and 8 of the EU Charter. Article 48 is a direct shield. It says a foreign judgment can only be recognized if it comes to a formal government-to-government treaty, a mutual legal assistance treaty. And Chapter 5 says data can only be transferred with an adequacy decision backed by fines up to 4% of annual turnover. The CJ used Prem's 2 ruling deepened this crisis by invalidating the privacy shield. And mandating the transfer impact assessment, forcing private companies to adjudicate whether US surveillance law is essentially equivalent to EU rights, a sovereign level question the court itself could not resolve. The corporations are thus burdened with an impossible task assessing classified US practices and concluding, as the court already did, that they fall short. And the technical sovereignty solutions like localized data storage as a mere illusion, because the Cloud Act's broad control test can legally compel a US parent company to force its EU subsidiary to hand over the data. The underlying legal war remains unchanged by the server's location. And I would like to give my recommendations. So where does this leave us? If the technical solutions fail and the legal framework is broken, so what is the path forward? The solution must be multi-pronged. First, we need a binding international convention on sovereign data request, moving beyond the slow, outdated mutual legal assistance treaty, that is MLAT, system to direct regulated interstate corporation. Second, we must pursue a clear normative convergence, not just in privacy standards, but also in surveillance safeguards. Creating clear, objective criteria for what an adequate legal regime looks like. And at last, we need an international arbitral mechanism, which is likely a neutral one, that can resolve jurisdictional conflicts between sovereigns before they land on the desk of Corporate General Counsel. The goal is to lift the sovereign conflict out of the corporate mailbox and back into the realm of public international where it belongs. I would like to conclude this. The digital world has erased borders for data, but reinforced them for law. Until our legal frameworks recognize that, we will continue to place corporation in an impossible and frankly unjust position. Thank you.
I thank all the presenters, acknowledge the presence of our honorable guests. I now invite Dr. Banerjee Chakka Sir, Dean, School of Law, VIT-AP, Dr. Anantu Sir, Assistant Dean, Dr. Bensha Sir, Convener, to felicitate our guests. I request the moderator of this session, Dr. Angel Shaji ma'am, to deliver the vote of thanks.
I extend my heartfelt thanks to our distinguished speakers, Professor Dr. Manimuthu Gandhi sir, Professor Dr. Rajalakshmi ma'am, for sharing your knowledge and expertise with us. To our participants and audience, thank you for your attentive participation and enthusiasm. Your presence has truly contributed to the success for this session. Once again, thank you to everyone for being a part of this session. Wishing you all a wonderful day ahead. Thank you.
With this session, we end our first day of Private International Law Conference. We expect the same enthusiasm for tomorrow also. I request all the faculty, PhD scholars, and the organizing committee members to stay back. Thank you.